Hello, friends. Welcome to the National Constitution Center. It is an honor to welcome you to our symposium about constitutional meaning in the shadow of the Articles of Confederation. Before we begin, let us inspire ourselves by thinking about this sacred space that we're privileged to convene in. And I want you to gaze at the words of the First Amendment that are shining behind me. And now I want you to turn your gaze and look at Independence Hall, the greatest and most inspiring constitutional view in America, on this gloriously sunny day with the light shining from that sacred space, and think about the great documents of human freedom that emerge there, the Declaration of Independence and the Constitution. And then think about the relationship between these words, the Declaration, the Constitution, and the Bill of Rights. And the relationship between those three documents is what we're going to be talking about today. We are convened to think about how the American idea enshrined in the Declaration was embodied in the Constitution and then codified in the Bill of Rights. And that is exactly the question that the Constitution Center is about to explore on an exciting new civic toolkit that we're launching in connection with America's 250. And we've convened some of America's greatest historians to write about the big ideas of the Declaration and the Constitution. Robbie George on liberty, Danielle Allen on equality, the great Gordon Wood on government by consent, Yuval Levin on the separation of powers, Judge Jeff Sutton on federalism, Mary Sarah Bilder on the Bill of Rights. Akhil Amar is going to annotate the entire Declaration of Independence. This will all be online, and it'll have clips from Ken Burns' amazing new film on the American Revolution. And we're going to send this out across America to inspire conversations about the relationship between the Declaration, the Constitution, and the American idea. I can't imagine a better way of setting the stage for the launch of this toolkit than today's symposium. Because the great event that connected the Declaration to the Constitution and set the stage for all the debates that would follow in American history are the Articles of Confederation. And the Declaration is adopted in 1776. Then we have almost a decade of Revolutionary era state constitutions from Philadelphia and Virginia in 1776 to Massachusetts in 1780 that begin to work out how to enshrine a structure of government and to both limit power and make possible common purposes. And then in 1781, the Articles of Confederation are adopted, rooted in the idea of state sovereignty, and they require unanimous consent before anything can be done, and they protect the autonomy of the states. The Articles famously fail. They fail to create a government strong enough to achieve common purposes, in particular security and trade, and as a result, there is upheaval and chaos culminating in Shays' Rebellion in 1787. In Western Massachusetts, farmers are mobbing the federal courthouse because they can't pay their debts. The troops are dissatisfied because they can't be paid. And the delegates converge in Philadelphia, in Independence Hall, to remedy the defects of the Articles and meet the exigencies of union, and to create a document strong enough to achieve common purposes, but restrained enough to protect individual rights. And that's the challenge of the convention and the great compromises of the convention over questions like apportionment and national power versus states' rights, and notoriously slavery, and the status of the Bill of Rights define the final document. And then we have the decade of the early republic in the 1790s, when the meaning of these great compromises are worked out. And the great debate between Hamilton and Jefferson on questions like national power and states' rights, and liberal versus strict construction of the Constitution, and democracy versus rule by elites defines the early government. I have this new book coming out in October about how that battle between Hamilton and Jefferson defined all of American history, and it's so exciting to see those great debates play out for the rest of American history during Reconstruction and the New Deal era and today. I've sketched all that because that's exactly what we're going to be talking about today. And it was the brilliant inspiration of the James Madison of today's conference, who is Maureen Edibar, who had the great idea of convening a conference to talk about the relation between the Articles of the Constitution and what came later. Maureen Edibar was reading Jack Rakoff's great book on constitutional meaning and thought she wanted to understand what really happened, what was the true story of the ideals that gave rise to the Constitution and how they reacted to the Articles. And she had the great idea of convening some of America's greatest historians and legal scholars to discuss exactly that question. And now I need my constitutional reading glasses to thank all of the great partners at the Brennan Center who had the inspired idea of making Maureen's idea a reality. I want to thank the president and CEO of the Brennan Center, Michael Waldman, who is here in spirit, although he was not able to be here today. John Cowell, who I'll introduce in a moment, Brian Palmer, Jay Swanson, Susan Augenbraun, and Terrence Francois, as well as the entire NCC team for making today's event possible. We're honored to partner with the Brennan Center in convening these great historians, and I can't wait for the panels that will follow, which will talk about the legacy of the Articles, how they were made a reality during the debates over ratification and early constitutional formation, and then how they played out for the rest of American history. And with that introduction, it is a great pleasure to welcome John Cowell. Please welcome him to the stage. There we go.
Thank you, Jeffrey, for that kind introduction. And thanks to all of you, and I'm sorry, thanks to the entire team here at the National Constitution Center for partnering with us to host this extraordinary event. For almost a quarter century, the center has been doing the vital work of educating the American people about our nation's founding ideas. Because at the end of the day, America is an idea. We, the American people, are not defined by our race, nor our religion, nor our political party. We're defined by our civic creed, our shared abiding commitment to the fundamental values embodied in the Declaration of Independence and the Constitution. And the National Constitution Center, here in Philadelphia, less than a mile from Independence Hall, looks closer than a mile to me, is a living monument to that creed. As Jeffrey said, my name is John Cowell. I work at the Brennan Center. I'm also the author of a book called The People's Constitution, which is the story of how the 27 amendments to the Constitution were added over 2 centuries in a remarkable story about making our country more democratic, more inclusive, and more suited to the needs of a changing country. I should note at the outset that Michael Waldman, our president and CEO, dearly wanted to be here, and he was unable to come due to family reasons. So I represent the Brennan Center. We're a hybrid organization. We're part think tank, part legal advocacy group, part communications hub. And our mission is to strengthen and reform the systems of democracy and justice in the United States. We're proud to be affiliated with NYU School of Law. On behalf of the Brennan Center, I'm very pleased to introduce this conference, Constitutional Meaning in the Shadow of the Articles of Confederation. The conference, as Jeffrey said, is the brainchild of Professor Maureen Edibar, who's here with us. She's our Poland Fellow in Constitutional Law and History. And we'll be hearing from her later in the day. When Maureen is not engaged in groundbreaking research or putting on really amazing public events, she's assistant professor of law at Washington and Lee University School of Law. Thank you, Maureen, for your vision and hard work in making this happen. Maureen's fellowship was made possible, it was named in memory of Stephen Poland, a lawyer in public service who dedicated his life to democratic values. Steve's wife, Elizabeth Roystacher, is joining us virtually, and she has made this fellowship possible. I also note that Susan Herman is very closely involved with the fellowship. Elizabeth, we thank you for your wonderful support. So why are we here to talk about the Articles of Confederation? We all learned in school that it was America's first and failed plan of government, that it aspired to be nothing more than a firm league of friendship among 13 independent states, establishing a weak government that quickly led to dysfunction and paralysis. Today, it was essentially a government of we the states, not we the people. Today, there's a tendency to ignore the Articles as little more than a false start. But what if understanding the experience of governance under this plan of government could help shed light on the Constitution that replaced it? As we know, the Supreme Court in recent years has increasingly relied on history to resolve some of the most important constitutional questions of our day. Relying on a theory of interpretation called originalism, many of the court's members argue that the original public understanding of the Constitution is should guide our understanding of its meaning today. Of course, it's not always easy to know what 55 founders intended, much less the hundreds of Americans who participated in 13 state ratifying conventions. But we do know that the Constitution was, by its own terms, crafted to form a more perfect union than the Confederation government provided. So shouldn't it follow that the Articles provide vital context for understanding the Constitution that the framers ordained and established for themselves and their posterity? We do know that back in 1787, when the framers of the Constitution met across the mall over here to negotiate a new and better plan of government, the Articles of Confederation were very much on their minds. After all, the delegates' charge from the Confederation Congress was to meet in Philadelphia for the sole and express purpose of revising the Articles. Behind closed doors, they did something different. They made the decision to scrap the Articles entirely and start over. But we can't avoid the fact that in many crucial ways, the Constitution they crafted was intended to improve on a system of government widely viewed to be dysfunctional. We can't, in other words, understand what our Constitution gets right unless we understand what the Articles got wrong. Although the Confederation period seems little more than a blip in the popularly understood narrative of American history, the Articles of Confederation have cast a long shadow over constitutional meaning for generations, up to and including the present day. Throughout our history, many politicians and judges and legal scholars have claimed that the framers of the Constitution bequeathed the government not that different than the Confederation, rooted in a very expansive view of state power and strictly limited federal government. It's enough to make one wonder, did the Articles really ever go away fully? We'll be grappling with these questions and more over the course of the day. We have gathered an all-star group of experts who are going to examine the Articles and their legacy from every angle. We'll go deep on what the Articles did and what the country looked like while they were in force. We'll hear about the role the Articles played in the framing of the U.S. Constitution, and we'll discuss how the Articles affected public understanding of what the meaning and promise of our Constitution was from the early Republic through the Civil War, through the Lochner Age and New Deal to the present day. And later today, Congressman Jamie Raskin, a leading constitutional scholar in his own right, will join us to share his own reflections. I began these remarks with some heartfelt thank yous to Jeffrey, to the Center, to Maureen, to Elizabeth. I also want to thank the Brennan Center's amazing events team, Susan Augenbraun, Terrence Francois, and Brian Palmer. And I also want to thank our senior fellow, Jay Swanson, who did so much to make this day happen. Finally, I want to thank all of you in the audience and online. Being an informed citizen takes work. As citizens of a democracy, we have a responsibility to educate ourselves and form our own opinions about our nation's origin story. It is my sincere hope that today's program will give us all much to think about. And it's fitting that we're having this conversation now on the eve of the 250th anniversary of American independence. I personally sincerely hope this celebration could be an opportunity to bring Americans together around a shared understanding of the values in our Charters of Freedom, the Declaration of Independence, and the Constitution. And with that, thank you again for coming. I look forward to a wonderful day of conversation.
Good morning, and welcome to our first panel of the day. All too often, discussions of our early history go straight from the Revolution to the Constitution, skipping the Articles of Confederation entirely. But part of understanding who we are as a country is understanding what we tried and rejected, or preserved. The Constitution was written in part to fix the Articles' mistakes. I'm really excited for this panel as our chance to understand the Articles themselves, and it's going to help set the stage for the rest of the day's discussion about the Articles' long shadow. I'm Alicia Bannon, the director of the Brennan Center's Judiciary Program and its Kohlberg Center on the Supreme Court. And we couldn't have a better group here today to discuss the Articles and their legacy. Please join me in welcoming our panelists. We have Aditya Bamzai, the Martin Lubin Karsh and Bruce A. Karsh Bicentennial Professor of Law at the University of Virginia School of Law, right at the very end. Farah Peterson, Professor of Law at the University of Chicago Law School, right in the middle. Johann Neem, next to Professor Peterson, the Professor of History at Western Washington University. And right next to me, Jack Rakove, co-professor of History and American Studies and Professor of Political Science Emeritus at Stanford University. Thank you all so much for joining us here today. And before we get started with the discussion, I'd like to remind the audience that there will be time for your questions. So please write them down on the index cards that you were given and raise them at any moment, at any point for a staff member to collect. So Professor Bamzai, I'm going to have you kick things off and really help level set the conversation for this panel and really the whole conversation for the day, so no pressure. Can you lay out for us what were the Articles of Confederation? How did they structure the national government and the relationship between the states?
Well, thanks so much, Alicia, for the introduction. Thanks to the event organizers for including me and for all of you for being here. It's truly an honor to be on this panel with Professor Rakove, who's one of the great historians of the founding era, with my old colleague, Professor Peterson, and to make the acquaintance of Professor Neem. So as Alicia just mentioned, she's asked me to set the stage with some foundational information on the Articles. So this is my attempt to do that with the very basics. The Articles, officially the Articles of Confederation and Perpetual Union. First, it is useful to start the discussion on a legal topic with a motivating question. And I understand, just based on standing in line, that John Kowal did a little bit of this in his introductory remarks, but let me set the stage again. Why study the Articles of Confederation? After all, they are no longer in effect. But that simple response tends to minimize the significance of the Articles. As we all know, the Constitution of the United States is in effect, and the Constitution was ratified and adopted in the late 1780s, in large part due to the perception among many that the Articles were defective. And as we know, questions about the meaning of the Constitution are much debated today. So studying and discussing the Articles gives us a window into what the Constitution might be understood to mean. Second, the basics of the Articles adoption. As you no doubt know, the Declaration of Independence was adopted by the Continental Congress on July the 4th, 1776, almost 249 years ago to the day. The Articles were debated almost immediately after the Declaration, finalized by the Second Continental Congress almost a year later, but did not come into force until 1781 in the midst of the American Revolution, after they were ratified by all 13 of the colonies. So now you'll no doubt be wondering why it took so long, from 1776, 77 to 1781, but that's a question that one of my colleagues will be addressing in just a few moments. For now, let me focus on two issues. One, what was the status of national assemblies prior to the Articles? And 2, what did the Articles hope to achieve? Specifically, how did they structure the national government and its relationship with the states? To start with the first point, there had been earlier pushes to increase cooperation among the colonies for decades, starting with what was known as the Albany Congress in 1754. And the reason for that is obvious. There was a need to help solve mutual problems. By 1775, the Second Continental Congress began acting as a provisional government for the colonies. And then in June of 1776, the Continental Congress appointed a committee of representatives to draft the Articles with John Dickinson of Pennsylvania as a chair. So the second point then, the Articles established what is often described as a weak national government with highly limited functions and powers. They did so in part to preserve the independence and sovereignty of states, which was top of mind during the drafting and ratification process. In fact, the final draft of the Articles made clear that each state retained its own sovereignty. The Articles also left significant practical matters such as the status of Western land claims in the hands of individual states. And the Articles did not allow Congress to tax directly, but rather required it to ask states for funding, which was a hugely important matter to which I will return later on in the panel. For now, note that Congress had the power to regulate and to fund the Continental Army. This is, of course, in the midst of the Revolution, but it lacked the power to compel states to provide funding for the troops or to provide troops themselves. Finally, and significantly, the Articles established a unicameral body, that is, a single body to act at the national level. Exactly what that body was, a legislative branch, a plural executive branch, a judicial branch, a supranational body, or all of the above, or none of the above, was debated in the years that followed. And I'll stop right there.
Thank you. So, Professor Rakove, I'm going to pull you into the conversation next. And as Professor Bamzai mentioned, the Articles it took some time for the Articles to be adopted. It was a full year of intermittent debates, over 3 years for the ratification process. Can you tell us a bit about what took so long? What were the sticking points? Tell us the story of how the Articles themselves were ratified.
Well, first off, the story is somewhat episodic. Congress spent a couple months debating the Articles of Confederation in June and July on into August 1776, which would turn out to be a rather dramatic month in the history of the revolutionary struggle. They suspended discussion. They resumed it again when they, in the spring of 1777, came upon the same stumbling blocks they'd encountered before. And then in the aftermath of the victory at Saratoga, they resumed discussion with the real intention to get the Articles done and finished, published, so that Benjamin Franklin, who was then off as our sole minister in France, could proceed at that point to complete negotiating a treaty of alliance and commerce with the monarchy of Louis XVI. I think the main stumbling blocks, if you go back to the initial debates, there were basically three issues dogged the discussions. The first was the question of representation. The argument had arisen in the First Continental Congress, which met, of course, at Carpenter's Hall and not at Independence Hall, or the Pennsylvania State House. What would be the rule of voting? And you had these interesting arguments coming from Patrick Henry and others as to, on what basis are we acting here as delegates from the states, or are we not all Americans with a common cause, and maybe we should just vote as individual delegates? But they came to their state as colonially appointed delegates, and they agreed to vote by delegation. That issue continued to be discussed off and on in 1776 and 1777. I think there are two reasons why they can not make any progress on it. First, if you want to have some kind of system of proportional representation, it means you have to start collecting the data. And how you would do that in wartime when the American state or states are so sorely pressed to get everything else done would have been a real challenge with their administrative capacity. So that's one explanation. I don't think it's the most important. I think the most important explanation, as I argued long ago in my first book, is that decision-making in the Continental Congress was essentially consensual in nature. In most cases, it wasn't about who could get 7 votes or eventually 9 votes were a major issue. Congress could only act when it was agreed on what its course of policy was going to be. And if that's your underlying model of decision-making, then having a rule of proportional voting is not going to be, it may seem unjust on the face of it, but it's not going to be the dominant consideration. So the grievance survived, and James Madison, when he plots his agenda for the Philadelphia Convention in 1787, insists that we should have proportional rules of voting in both houses of Congress. But, that's a story that has to be told and resolved later. So that was problem number one. Second problem was how do you apportion the common expenses of the Union among the states so that the states can levy taxes upon which the Continental Congress will rely to maintain its own expenditures. It also actually have sources of income that will prove attractive to would-be European investors who may not expect to be paid off immediately, but would like to know that the new unions are going to be more or less financially tangible or fungible or whatever. And so here you have disagreement over what's the appropriate basis in terms of schemes of taxation for allocating the common expenses. You can make arguments about the value of land. You make arguments about do it on the basis of property. There's a common motif in this period that perhaps population is itself the best index to wealth. So if we just count bodies, we'll get a good algorithm or whatever for allocating the expenses. But that doesn't get very far, and in the end, Congress bogs down on this. The New Jersey, I suppose since I'm in Philly, I should say the New Jersey delegates kind of come up with, they wind up in a sense being the swing vote, and they come up with a complicated and wholly impractical scheme that the allocation of expenses should be based on the value of assessed property, primarily land values throughout the counties. Again, another scheme which might have some appeal in theory. It's going to be highly impractical given the circumstances of wartime governance. So those are the two issues that mattered most. But the one that was really decisive that explains why does it take so long, why does it take into the winter of 1781 to get the Articles ratified is the whole question of Western lands. Mm-hmm. It's a small group of primarily landless states, primarily, again, New Jersey, Delaware, and critically Maryland. Pennsylvania, in a sense, is a landless state because its western boundaries are fixed, but it has enough land, it's not going to worry. So those 3 states held out on ratifying the Articles. I should have added that when Franklin gets the victory at Saratoga behind him, the French conclude a treaty with us very quickly. And Congress is anxious to, at that point, get its own authority confirmed. So Congress gets together, kind of rushes through a set of resolutions, I think the late spring, early summer of 1778, to get the Confederation ratified by all 13 states. That's fine, except Delaware, New Jersey, and Maryland drop out. And their argument is that the states which have, particularly Virginia, but not only Virginia, which have claims to Western lands are going to have this relatively profitable or lucrative resource upon which they can draw. So their ability to fulfill their financial debts to the Union will be fairly easy for them to resolve. The so-called quote-unquote landless states don't have the same resource. The other thing that's tied in here is that there are land speculators at work who are trying to validate their claims to Western lands, which essentially means the old Northwest Territory west of Pennsylvania, north of the Ohio River. It's primarily Virginia's grant. So Maryland holds out into the winter of 1781. Eventually, the French put some pressure on them because the British are rampaging through the South at this point, and it's kind of a hell or high water moment to finish them. I think the key point you made is that by the time the Articles are ratified, schemes for amendment were already afoot. There's the first impost that already went out to the states in, I think, February 1781, some weeks before the Articles finally took effect. And Alexander Hamilton, I think particularly a number of figures in the Army already realizing that the Articles as drafted are wholly inadequate to the needs of the Union. We have to start thinking in bolder terms about a true national government.
But then amendments required unanimous.
So amendments to Confederation fall under the same rule as the original Articles. And that's why in the end, in 1787, particularly I think when Rhode Island more or less checks out, Madison, the framers, and the Federalists realize we have to abandon the framework. We have to abandon the whole amendment framework. We're going to do it on some kind of super majoritarian grounds. If they're non-assenting states, well, tough luck.
Thank you. So, Professor Peterson, I'm going to turn to you next. And I think it's not a spoiler to say that the articles, it didn't work out so well. The weaknesses were apparent pretty quickly after adoption. Can you talk to us a bit about the biggest problems that emerged with respect to how the government was structured and why things devolved so quickly?
Well, I think we can overemphasize sometimes the importance of the articles and their written structure. Because after all, by the time they were adopted, the United States had already been at war, had been funding a military, had already concluded its first treaty with France. It was doing everything a nation must do. And there was no time to wait for the articles. In fact, as ratification dragged on and on, Thomas Jefferson's opinion was, if we needed a written constitution, we have it in the Declaration of Independence. The final provision of the Declaration gives us the right to conduct war, conclude peace, engage in commerce, and everything else that nations have a right to do. So what were the problems with the articles? It's both a matter of how they were written, but also how their writing reflected the realities of the time, the political realities of the time. That included the fact that it was only at the local level that any administrative capacity existed in these early states. It's true that the articles didn't give the national government the right to tax, but it's unclear how they would have done so, especially at the beginning of the war, when there was a blockade of the ports. So taxing imports was not a solution. Even during the Constitutional Convention, when the founders were debating the taxing power, which would be so important, I think it was Gouverneur Morris asked, well, what exactly is meant by direct taxation? And nobody answered. Because the idea that the federal government could reach its hand into every American's pocket was just so preposterous as a practical matter. And in fact, the federal government didn't have an income tax until the 1860s. So what were the problems of governance? I think it was a crisis of confidence, really, combined with the difficulties of funding the war. At first, there was a wave of enthusiasm right after the Declaration, and we even had voluntary joins to the Continental Army. But that enthusiasm dropped off very quickly. And there were two main problems, I would say. One was Congress's obvious incompetence at managing the military and the war effort, which was its main job. The Army was poorly supplied. It was unpaid. The soldiers were starving. At first, the conscription periods were so short that soldiers returned home before they were competent soldiers. And the other was the currency crisis. And of course, these two problems were linked. Congress could not collect the funds it needed directly from the states, in part because states had their own issues, their own militaries to fund. And so it started printing money. It started printing money in that time were in the nature of bonds, papers that said, at some future time, the Continental Congress will redeem these in hard currency. And of course, that kind of currency relies on faith. Faith that the United States would be a going concern, faith that these bills would someday be redeemable. And the crisis in the war meant that that faith became lower and lower, and so the currency became, we had a runaway inflation problem as it depreciated more and more throughout it. By 1779, there was such a crisis that the phrase "not worth a continental" had entered general parlance. So why didn't the articles work? It wasn't just because of their structure. If it was just a matter of getting the words right, and if everything would have flowed very easily from getting the words right, then the Articles were fine, because they said that states shall comply with all the decisions made in Congress, that states shall tax in order to defray the common costs of war whenever Congress asked them to. That wasn't the problem. The problem was practical, and the problem was one of allegiance, faith, confidence, which became lower and lower over the course of the war.
Thank you. Professor Neem, I'll turn to you next to, welcome, of course, any further responses to that question, but then also to talk a little more about civic virtue, which might be a little bit of what was embedded in some of what Professor Peterson was speaking about as well. This was seen as a critically important value in early America. To what extent were concepts of civic virtue embedded in the Articles, and why wasn't civic virtue enough to enable effective governance, as Professor Peterson was describing?
Yeah, thank you. And I like this question because it's about us, right? So if you think about the 1780s and the purposes of the Articles of Confederation, the purpose of the Articles is to maintain a confederation that will sustain these new republics. And so the thing we have to think about is, how do you sustain these new republics, right? What holds a republic in time and space, right? And if the character of, let's say, a monarchy depends on the quality of the king, as I tell my students, then the character of a republic depends on, and I look at them and they're a little nervous about that. Depends on the quality of the people, right? It depends on the character of the people. So the founders had the idea of civic virtue, which is the idea that in a republic, because it's a collective enterprise, in fact, a republic is a community, it's a commonwealth. And in a republic, the collective is the citizenry, and it's the job of the citizens to put aside their petty interests to serve the common good. And so many people today, and then also started to think about politics as, how do I achieve my interests? Where the entire premise of a republic is that the people are capable of putting aside their interests. So you have these republics that are dependent on the people, and the United States is going through an economic crisis, it's coming out of a war, there's some radical constitutional projects going on in every one of the states about how to create republics at the state level. And then you've got this League of Friendship called the Articles at the level of Congress, at the national level. And they don't always align. And that's part of the problem, right? That the interests of all the 13 republics don't always align with the national interest. And so you have a built-in tension. I think, the framers of the Articles probably thought, well, the republic, the citizens will know that the needs of the nation are paramount because that's the only way to secure the republics against threats, foreign and domestic, right? That people will have to care for the welfare of the nation. But in fact, that wasn't working out. And so Madison does a study of all confederacies he can think about, ancient and modern, and he comes to the conclusion that confederacies tend to, if they're not well designed, they tend to fall apart, that there's always some fatal flaw. He calls them the vices of various confederations. But Madison loses faith, to build on this idea of faith. He loses confidence that the people themselves can get there, that the people of these 13 republics, without some national correction, will be able to see that common good. And he's sitting there in Congress, seeing the United States government go broke, seeing military threats on all sides in the West, in the Atlantic, in the Caribbean, and he's seeing that Congress won't survive. And if Congress fails, the United States fails, the revolution fails. And if Congress fails, that means these 13 republics that are fragile will fail. So that's Madison's perspective. But the citizens often, at the state level, aren't always convinced by that. So Madison is looking for a solution that will sort of align the interests of citizens with the interests of the nation as a whole.
Thank you. And just to pick up on what both of you were saying, I think there's a really interesting thread that I just want to pull on about this question of to what extent were the challenges with the Articles about structural defects versus other things, either challenges, just bad governance, or limits in terms of state capacity that had nothing to do with the Articles, but were just the fact that there was a war, there were lots of limits on the ability for an effective national government. And so I guess I would just welcome responses from the rest. If you were to identify, were there fatal flaws with respect to the Articles of Confederation? Was there something where structurally that really, there was no version without fixing that structural defect that things could have worked? Or not? Was it really more a story of other governance challenges that were really affecting the ability for the Articles to be effective? Anybody would like to, please.
So what Jack said before, that it was, that the Articles set up governance based on consensus, was a real problem. Because even when the states had 8 votes, they could not get to a decision on a very important issue. And especially after the war, this became a huge problem. But I think that to just tease out one of the aspects of this idea of virtue, for leaders at the national level, it was very clear that that virtue was commitment to the project of the whole. But Americans had declared independence in order to pursue what some saw as a very different goal, which was local governance, and to commit to the principle that it was only people who were actually represented in their governance that could have a say in how to commit the resources of the community. And during the Revolutionary War, that principle meant that states put their own citizens first, and they thought that that was the virtuous path. So if they would have had to take funds and provisions away from their own militia in order to fund the Continental Army, that was a losing proposition. If they had to demand that their own citizens allow officers of the Continental Army to quarter in their homes without due process, that was a problem for them, because they had committed to this project, becoming traitors to the only government they'd ever known, for real principles, and those principles meant republicanism at the local level, not commitment to a distant authority that demanded things that were difficult or impossible for the local public to provide without dramatic sacrifice.
Jack.
I think I'd build a little bit on what's just been said. To me, the dominant, well, first off, I'll say, in a certain sense, I think of myself as a Madisonian in terms of not only what I study, but increasingly how I think. And I think Madison's dominant analysis of what he called the vices of the political system of the United States pivots on several points, but from the perspective of the Articles, it pivots on the key point he makes in the 7th of 11 items, which discusses the want of a sanction of coercion in the Continental Congress, meaning Congress has no authority to coerce or compel the states to perform their duty. Madison then launches into what I think is the single most brilliant paragraph of political analysis in American constitutional history. He says, look, there are basically 5 causes, or 5 ways we can think about this. 2 of them are historical. The first is I think Johann and others previously intimated. Back in the day, meaning back in the mid-1770s, we simply assumed the states would do the right thing. We were all patriots. We're caught up in the so-called sunshine patriotism of 1774, 75, 76. We felt that enthusiasm would be enough. Turns out that was not true. Second, even in wartime, when we should have learned the lessons because of an external threat, we found the system breaking down. So even external danger doesn't always do the job. But then he launches into what I think, and I've written about this in various places, what I think is recognizably a game theoretic analysis of the problem of federalism. He says there are 3 other reasons at work here which will prevent us getting an adequate or fulsome level of compliance from the states. First is, states have a variety of interests, so we cannot assume that they're equally inspired to respond adequately in any given situation. Second, there's what I now call the running against Washington problem. Within every state, you'll find courtiers of popularity. I think he's thinking first and foremost about Patrick Henry, who are going to have their own political interests to pursue, their own ambitions to court by opposing measures coming from the national government. And then third, what I think is the most ingenious argument, he says, look, even when we have a common interest, and we might actually agree on what the policy ought to be, if we have collective doubts about each other, no one's going to be the first to comply. So there will be a net drag in the system. So I think in that sense, and at that point, Master reached the conclusion, under these conditions, the operative phrase is, this situation will never fail to render federal measures abortive, meaning the system's always going to be prone to breakdown. So therefore, you need another system. That other system has to be, the national government has to be able to act legally in the full sense of the term. Unlike the Continental Congress, it has to be able to enact its own laws, execute its own laws, and adjudicate its own laws. Second point, I'll just make quite quickly, and it comes back to what Farah was just saying, there were particular moments in 1779, and I think more dramatically in 1786, when it's no longer clear what is the common national interest. 1779 has to do, there's a danger of peace negotiations when the British are occupying a big part of the South. What kind of peace settlement will you reach? It might be good for New England, not so good for North Carolina and Georgia, South Carolina and so on, which are facing military occupation. And then 1786, you have this great crisis over American rights to free navigation of the Mississippi River, which is dividing the Congress into blocks of 8 states and 5 states. And as Farah noted, for John Jay to negotiate the treaty that was in question, you would need 9 states to ratify. The northern states couldn't get to 9. The southern states had their 5, but it's just a formula for the question: do we really have one durable or perpetual confederation, or might it break up or break down into 2 or potentially 3 sub-confederacies?
That's fascinating. Johann?
Yeah, one way, just to build on this, to think about this is, so Jay opens the Federalist Papers, John Jay, with an analysis of international relations, right? And so if you have a confederation of states, one of the primary purposes is military. It's to create a defensive league. And one of the things, just building on this idea of playing out how things might have worked out, is Jay points out that actually, if we don't find a way to cement the Union, the states, because of their divergent interests, will start reaching out to other alliances to pursue their goals if the confederation is not strong enough. And so if we don't do something to bind the states together, as the states pursue their separate interests, they may end up allying with Spain or with England, with indigenous tribes, with France, and they may find themselves embroiled in war with each other. And if that happens, this whole hope that these republics will sustain themselves over time, the states, the local republics, will sustain themselves over time, will disappear. And so there's a tension ultimately built into this vision coming out of the revolution of an active citizenry participating at the local level in their self-governance, and the kind of anarchic tendencies of the 13 states pursuing their own interests. And the people going to Philadelphia trying to figure out how to resolve that tension.
And I'll just give a reminder to the audience that please write down any questions that you have on your index cards. We're going to leave time at the end for this wonderful panel to answer questions as well. Farah? Farah, I mean. It's true that this was a problem of how the Articles were written when the United States concluded its peace treaty with England, the Treaty of Paris. It could only agree to earnestly recommend that the states follow various key provisions in the treaty, including the provision that they wouldn't retaliate against loyalists and confiscate their property, something that the states found to be an overstep. And so immediately after the treaty was passed, and in part in reaction to the treaty, 6 states passed laws confiscating loyalist property out of pique that the national government would presume to regulate something so internal. So that was a structural issue. But how to fix it was a real problem. Madison's favorite solution would have been a prior veto power in the national government of all state laws.
before they went into effect. And he lost that vote in the convention. Washington initially thought there must be a power to force them by military means to comply with the national government. But eventually, Madison convinced the convention that this was impractical, that it would risk a constant state of civil war. And so what they were doing in the convention was trying to construct a structure that would motivate the various players in the system to act in ways that were mutually reinforcing instead of divisive. This is a broader application of the principle that Madison mentioned in Federalist 51. They need to make ambition counteract ambition. How did they do that? It's not just, again, it wasn't just getting the words right, whereas they got them wrong in the first place. It was about constructing different levels of government, different forums for the resolution of governance issues that would behave in ways that were more conducive to national strength than division.
Thank you. So we've already started talking about some of the different controversies, crises, challenges that we saw during the period of the Articles. Professor Bamzai, I'm going to pull you in now to talk about another one of these, which was the impost controversy, the call to give Congress power to levy a tariff on foreign imports. Can you tell us a bit about that history?
Absolutely. And in fact, as my co-panelists were talking, I was reflecting on the very deep question that Farah kicked off and then Jack and Johann weighed in on, which is how much of the breakdown of the Articles of Confederation is dependent or is the result of character? How much of it is character and how much of it is words? The text, how much did the text get things wrong versus were the American citizenry the issue? And I think these questions are maybe not related to one another, and they're reinforcing in the sense that words can have an influence on people's characters. And one way to address that broader question is the very, very significant criticisms that were lodged against the Articles about the fact that the Continental Congress could not directly raise taxes for the national government. So the Articles had some language in them that preserved this robust conception of state sovereignty. In fact, they declared that each state retains its sovereignty, freedom, and independence in every power, jurisdiction, and right, which is now by this confederation expressly delegated to the United States. And then with respect to taxes in particular, the Articles said, and this is a quote, that they shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States in Congress assembled. So there's some language in there that sounds as though it's imagining and almost requiring states to levy taxes, but there's some language in there that suggests that, Congress might have to recommend to the states that they levy taxes. And in fact, then in 1781, during the Revolution, shortly after the Articles were adopted, or around the same time, Congress requests that each state vest a power in Congress to levy a tariff of 5% on foreign imports. And the initial holdout, as Jack mentioned earlier on in the conversation, to this proposal was Rhode Island. And they rejected the recommendation through a letter from the Rhode Island Speaker. And the Speaker gives a number of reasons for why Congress should not get this authority. But an interesting one is that it would introduce into this and other states officers unknown and accountable to the states. And so it's against the Constitution of Rhode Island. So that is, again, picking up on this theme that occurs during the American Revolution, that there should be some sort of accountability that these officers have to the people. And the Speaker of Rhode Island is saying, who are these people who are going to come into our state from outside the state in order to raise taxes by this 5% tax on imports? Well, so that 1781 proposal doesn't work. And in 1783, Congress tries again, and they say, well, we'll have a duty of 5% on goods, and they accommodate Rhode Island's objection in a couple of ways. They say, we will allow the impost to expire in 25 years. And then second, they say, the states can appoint the tax collectors, and we will have the authority to remove them. So there's some sort of accountability mechanism that's being built into this new taxing regime. That doesn't quite work, and in 1786, Congress tries again, and it's New York that is the holdout at this point. And as you can imagine, New York, both as the state that, it's the key to the whole national project working, because so much of foreign commerce is going through its ports. So in 1786, the state legislature in New York enacts an impost law that does grant Congress some authority with respect to duties on imports, but it vests in state officers the power to levy and collect the duties. So by implication, the tax collectors are responsible to the state, not to the national government. And Congress recognizes this measure as effectively a repudiation of its own request. It says to the New York governor, George Clinton at the time, hey, please convene a special session to reconsider the bill. And the special session also results in another rejection of this impost authority. So what you can see is that in 1787, there are these years of twists and turns, and ultimately they lead to New York's rejection of Congress's authority to implement this impost effectively. And that 1787 rejection is the death knell for the proposal. And James Madison, when he is then spelling out the flaws of the Articles of Confederation in 1787, he places this inability of Congress to raise taxes at the very top of the list. And he says New York's rejection was not just the death knell of the proposal, but the effective death knell of the Articles. In fact, Alexander Hamilton has some notes for speeches that he delivers at the Constitutional Convention, and among the notes, he says, impost begat the Constitutional Convention. Begat, gave birth to. So I think that this whole controversy both gives a sense of how much of this was related to character of the people of New York, who perhaps wanted to control the duties that they could impose on foreign imports into ports of New York, and there was a faction within the state of New York that had an economic interest in controlling those duties. And it also related to the words that you can see in the Articles of Confederation. How much authority did they actually give the national government? Along with all of that, there were disputes within the New York State Legislature about whether the New York State Legislature could delegate to the federal government this additional authority. And those questions of delegation become front and center when the Constitutional Convention kicks off. Perhaps we'll return to that at some point, but I'll stop right there.
No, thank you for that. Speaking to, and I do think it's fascinating just looking at, I read your article and how just this concept of how they were saying, well, we can't do this. Our state constitution says that we are barred from cooperating in that way, and just what a different mindset than in our contemporary, under the US Constitution, where obviously we have a Supremacy Clause. You're not going to have a state constitution barring cooperation with the federal government in that same way now. So I thought that was just a fascinating example of just the very different mindset that existed in the period of the Articles. We have a few more minutes before turning to Q&A, so I'd love to spend a little more time talking about some of the various crises in the lead up, and would also welcome anybody who'd like to weigh in on just what was top of mind with respect to the framers when they actually gathered in the Constitutional Convention. What were they worried about? What was the experience of governance or other crises that were most prompting, were prompting them to focus on the questions they focused on during the Constitutional Convention? So, maybe I'll pose that question to all of you, and Professor Peterson, when you answer, if you could also maybe talk a bit about Shays' Rebellion as I think one piece of the story of the lead up to the Constitutional Convention as well. So maybe I'll turn to you first.
Okay. Well, so one thing you just said piqued my interest, which was obviously the Supremacy Clause means that under the new Constitution, states could not do the things that they did under the Articles, but that's just not not the case. The supremacy of the federal government was years in the making, and it wasn't fully complete or settled until after the Civil War. It was one of the accomplishments of the Union Army. In the 19th century, there are innumerable examples of states rebuffing the authority of the national government. To think of two, in South Carolina, there were what they called Negro Seamen's Acts. That is, if free black sailors docked in Charleston or any other place on the coast of South Carolina, they were not allowed to wander freely. They had to be confined to jail until their ship re-embarked in order to protect South Carolina from the intellectual contagion that free black sailors might introduce. This was a violation of the nation's trade agreements with Britain. Many of Britain's merchant sailors were free black sailors. They were a large proportion of the British citizens that docked in South Carolina. And Britain's foreign ministers were continually raising this with the Secretary of State, but there was absolutely nothing they could do about it. Also, in the War of 1812, the Constitution was as much a military as a civil document, and it established that during times of invasion, the commander-in-chief of the army would also be the commander-in-chief of the militias. That is not how the New England governors decided to interpret those provisions. And because as a practical matter, they were in command of their own militias, they declined to participate in the invasion of Canada, which was one of the national government's primary military objectives. So these are just
a great point. It was a long path to get from there
very
to,
long
to
path
here today.
to supremacy. So, you know, why? Why did the national government become supreme? It's a matter of cultural change, really. And to the extent that they gleaned some new powers immediately, it was in part because the experience of the war and the decade, what we call the critical period afterward, convinced many that it would actually be useful to have a national government in charge of, for example, foreign affairs. Without that broad-based agreement, it's unclear that Washington would have consolidated power so quickly. And of course, we have to take into account that it was Washington who was at the head of the new government, a person who had garnered quite a bit of charismatic power. Okay, so what was most important? It has to be in part the tariffs. The power to impose tariffs in the Constitution was very important. It helped fund the debt of the Revolutionary War. It was, in fact, the way that the United States government was funded for 100 years. And imposing other kinds of taxes, excise taxes, led to conflagrations like the Whiskey Rebellion. It was very dangerous for the government to impose taxes in other ways. The Supremacy Clause, of course, and the creation of a federal court, but also the Contract Clause. It has to be listed as one of the main prompts, one of the main gains of the Constitutional Convention, and that's because of things like Shays' Rebellion convincing so many that the real fact of democracy in the states, the fact that agrarians in the west of these states, debtors, the lower classes could combine and implement legislation that victimized creditors and other financial elites, that was a major prompt to the Constitutional Convention. And at some points, convention delegates admitted to themselves that this was perhaps the most important thing they'd come together to establish.
Great. Professor Rakove.
I want to back up on Farah's concept of supremacy. So the Supremacy Clause says, this Constitution, laws made in pursuance thereof, and treaties made under the authority of the United States shall be the supreme law of the land. Nothing in the Constitution, the laws of the states to the contrary, notwithstanding. I may have mangled the second half there, but that's roughly the gist of it. You have to ask the question, what makes the Supremacy Clause itself supreme law? And it's a bit of a trick question because one of the underlying puzzles of the Constitution is how, or really the constitutional history more generally is, how do you turn a constitution into supreme law itself? What differentiates a constitution from other forms of legal action? And there is a somewhat technical but also conceptually powerful argument which says the documents approved by a legislature or by a body acting in a legislative capacity are themselves only legislative in nature. And because one legislature cannot bind its successors, any constitutional decision made by a legislature will not itself be fully constitutional in the robust, complete sense of the term that we now use. So it is one of the great puzzles of from 1776 down to 1787. How do you make a constitution fully constitutional? How do you make it into the supreme law of the land? And the answer to this is what it's worked out first in Massachusetts in a somewhat complicated and messy and protracted way, and then it's generalized more specifically in 1787, 1788. Unlike the Articles of Confederation and its amendments, you cannot submit the Constitution to the state legislatures. Their only role will be to arrange for the election of delegates to the so-called ratification conventions. The first of which met was, of course, the one that met up the street here in Pennsylvania in the fall of 1787. So those conventions, even though we could say this is a kind of a legal fiction, nevertheless, I mean, the conventions are representative of the people, well, so are the legislatures. But if you call them for a unique purpose, they can only act constitutionally and not legislatively. The nature of their action is therefore differentiable from ordinary legislation. So what makes the Supremacy Clause supreme is not only its language per se, but also the foundation, the underlying foundation of the Constitution itself, which is to come up with a method of how do you distinguish the Constitution from other forms of legal action.
More on what was top of mind with respect to the framers when we entered into the Constitutional Convention. Professor Bamzai?
Yeah, so I've already talked about the impost controversy, and what's really interesting about that whole controversy is that there's both the economic angle, obviously the control of taxes is very important to the functioning of either the state or the national government, but there are also these legal points, which I think if we were to distill them, might amount to the following. It is, we already have our own Constitution, thank you very much. We have the New York Constitution, and we cannot violate our own Constitution by delegating this additional authority to the national government. And there are all kinds of intricacies in the claims people are making about the New York Constitution at the time. But we can set those aside and just think about the broader question of sovereignty. Where does sovereignty reside? Is it in the states or is it in the national government? And that question, which is at stake in the impost controversy, it then plays itself out into the steps to the Constitutional Convention in 1786 and 1787. And so in the article that Alicia kindly referred to just a few moments ago, I have a little summary of there's some letters exchanged by John Jay, who is at the time the Secretary of Foreign Affairs for the Confederation, and George Washington, who's out of office. And Jay's asking, well, are these state legislatures authorized either by themselves or by others to alter constitutions? Can they alter their own constitution? And he says, well, maybe the people who would hold commissions and go to the Constitutional Convention, by virtue of those commissions, they couldn't retrench on or extend the powers that are conveyed to them. So they'd be limited by their own internal constitutions. And there's a question at the time the Constitutional Convention is being planned whether there could be alterations in the state governments or in the national government, and that would ultimately play itself out in New York through this series of resolutions when delegates are being selected to go to the Constitutional Convention, asking that the delegates not adopt any changes to the articles that are repugnant to or inconsistent with the Constitution of this state, New York. And somehow Alexander Hamilton is able to maneuver in the state legislature of New York and ensure that that resolution is not adopted, But in fact, there's a commission that is given to the various delegates to the Constitutional Convention. There are two, Abram Yates and John Lansing, and Alexander Hamilton is the third. And two of them, Yates and Lansing, they depart in the middle of the convention, and they say, well, we were given limited and well-defined powers by the state of New York, and we can't possibly go beyond that. We can't construe these powers that we were given in our commission to come up with a new constitution and abandon the Articles of Confederation. And there's then, this then leads to this very consequential rebuttal to the argument which you can find in Federalist 40, which is authored by James Madison, where he's talking about how the powers of the convention can frame a national government. And even in the last gasp, when you approach the ratifying convention in New York, there are various of the anti-federalists who say, well, instead of revising and altering the provisions of the Articles of Confederation, these folks in the Constitutional Convention, they've just come up with a new Constitution of the United States, and it violates our commissions that we gave to the various delegates. So I think that the really important taxing and economic issue plays out both on a political and policy-based trajectory, as well as this set of legal questions about what's the source of sovereignty writ large.
President.
Yeah, I guess just sort of pulling these pieces together, if you think about it, right, obviously, and this is somewhat trite, but it's really important, is what is on the people's minds as they're walking into the convention is how do we make the Union survive? How do we ensure the United States doesn't go belly up? And that is the fundamental question everyone's bringing. But then as you're sort of hearing this conversation, there's part of it that you've got a bunch of tinkerers, right? And they're like, okay, well, that's an easy fix. You give certain new powers to Congress under the Articles, and a lot of those powers end up in the Constitution. Supremacy in certain places, taxation authority, issues of Western lands, all these kinds of problems that the Confederation couldn't solve. Let's resolve them by granting more powers to the Congress. And so there's a kind of practical group of people who are like, let's just go in and fix these problems and we'll have a stronger Confederation. And in fact, I think to your point, when Madison sort of shows them what he has in mind, it opens a whole new window, right? Like this, and that window could be a source of fear and panic, like this is a threat to our sovereign republics, but it also is an act of imaginative creativity, because it's a moment where people start to see the possibility of another kind of way of organizing the people of the United States and putting them together. So you also have, so we can see the convention simultaneously as a kind of group of tinkerers who like put a bunch of powers, and the remnants of that is in the contract clauses, all these language specific terms that enter into the Constitution, but then this imaginative act that opens a window to rethinking the very nature of the United States. And those things sort of come together in Philadelphia.
Thank you. I'm going to turn now to some questions from our audience. So the first question, and this is directed just to anyone on the panel that would like to engage, were there ideas in the Articles that you think the Constitution's drafters should have preserved? So were there aspects that we should be trying to resurrect, or at least at the time that the drafting took place should have been maintained?
Well, I have a somewhat quirky one which relates to the current state of the body politic. So let's assume, as I am now doing increasingly, that we're at a moment of constitutional failure, not wholly different from 1787. I've started, and Farah and I were talking about this briefly before, I started to wonder, suppose, I think the United States should try to remain a superpower, but, you know, I live in a blue state, and I've always lived in blue states most of my life, and perfectly happy to do so. I found myself wondering about one of the core conceptions of the Confederation is the notion of internal police. Actually, when you talk about sovereignty under the Articles, there's a kind of external issues, you know, war, diplomacy, primarily, and then Article 2 kind of, you know, I think it's a phrase that Connecticut delegates in particular, like the idea that a state should retain control of its own internal police. Police in the police part in the 18th century, 19th century, we no longer use it the same way. When we think police power, we think the police, the cops. But police power then meant the general authority of a jurisdiction, to legislate broadly for the collective wealth, health, and safety of its population. Living where I do in California, feeling we're actually pretty well governed in terms under which I'm comfortable. I was wondering, well, why not, if there are fundamental social differences of a kind between, for better or for worse, red states and blue states, why not a confederation? I mean, it'd be funny. We could set up a great healthcare system on the West Coast. We'd start with the 3 coastal states, California, Oregon, and Washington. You got to bring in, probably bring in New Mexico and Arizona's in between, so squeeze them in. They have a lot of retired old people, so they want to have a good healthcare system. So take that as one example. I have found myself thinking somewhat wackily, but not implausibly, about the idea of what would a contemporary confederation look like.
Anyone else want to?
Well,
I can't think of one. I think I'm, in general, in favor of the changes that were made over the course of the 1780s and result in the Constitution. But there's I'll use it as a launching off point to one theme that we've not addressed in our remarks up to this point, and that is, as I mentioned early on, the Confederation, the Articles create this unicameral body, and it's just one body, and it does all the national business. Whereas the folks who write the Constitution, they split, as you well know, the federal government into 3 branches, the executive branch, the legislature, and the judiciary. And this then has various consequences for how we implement policy through the national government. So,
but Aditya, it's critical to note, and we're easily confused about this, the Continental Congress was not a legislature. It operates with legislative procedures. When it has roll calls, it appoints committees, they present reports, and familiar modes of deliberation. But in terms of the rather nebulous conception of separation of powers, the Continental Congress is actually an executive body which operates under legislative procedures. And I think the best phrase for this is one that comes from a guy named Thomas Burke, who was a truly states' right-oriented delegate. Actually, the main author of, the main interpreter of, I think of Article 2. Burke calls Congress a deliberating executive assembly, which captures the essential ambiguity of the institution itself. It looks and sounds like a legislature in some ways, but its powers are actually quite different.
Yes. Professor Neem and then Professor Peterson.
No, just one quick thing that's building on these comments is, in the 19th century, they often talked about the Union. And so for us, when we think about the 1780s and the formation of a national government, we're living in a reality that imagines a national government that's post-Civil War and post-New Deal. So we're imagining a national government that, as we're seeing in the news today, has all these levers that determine the stability of almost every institution in the country, right, private or public. And because of its capacity to generate and distribute wealth through taxation, because of its immense police power, immense power over policies all across the Union, and so all across the United States. And a 19th century understanding would have been that this was a union, and you're fighting for a union so conceived that where there's a lot of local distinction and difference. And those local differences were handled at the local level. And they just imagined the United States very differently than we do today, living in a world that is so national. Now, just to be clear, some of the benefits of that national has been civil rights, right? That it's been the national government that's generally been interfering with local governance on behalf of civil rights, and regulation of businesses when they went national, right? When they could no longer be governed by local law. But at the same time, I think you're sort of asking us to sort of imagine are there different ways of imagining how the pieces fit together. And in the 19th century, they wouldn't have our understanding of what the nation looked like. They would have had this understanding of a union still.
Professor Peterson?
Right, so I was just thinking as Aditya was talking about this concept of the all-in-one deliberative executive assembly. And I mean, you could say that this is one of the problems of right now, and part of our constitutional crisis is To borrow a phrase from Madison, the executive is absorbing all powers into its impetuous vortex, right? Trying to usurp the powers of the judiciary, rule by executive order instead of delegating this kind of legislative authority to Congress, and that's the problem. And one of the gains of the new constitutional system was different forums that could be captured by different interests at different times and different procedures of decision-making. It's through these overlapping, these redundancies in government that we maintain liberty, because it's just more difficult to establish despotic rule when there are different bodies that have to commit to and be involved in that rule. Anyway, I think that the thing that the Constitution got wrong was the Fugitive Slave Clause. This is not a problem for us today, obviously, but the Fugitive Slave Clause meant that the pre-Civil War United States was not half slave, half free, as Lincoln put it. It was, in some senses, all slave, because if a master or his agent has the right to pursue a slave into a free state, the lash and the chain goes with him. And I just wonder what the nation would have looked like in the antebellum period without that constraint.
Turning to another question, were there different stakeholders involved in drafting the Articles versus the Constitution? And if so, did that inform the different approaches of those documents?
As stakeholders, I find that a hard concept to work in here. I mean, I think I suggested before, the interests that mattered most were the claims about Western lands. Mm-hmm. So I mean, those are stakeholders almost in a literal sense of the term, like let's survey the land and who owns it, or who has a plausible claim to it. You know, again, you go back to, I mean, I think the decision just made that Congress, the Continental Congress lacks legislative authority in the ordinary sense of the term. So I think stakeholding is defined in a certain sense, just think out loud on the subject, by the existing legal regime that affects one's daily or recurring actions, that all the authority that really matters devolves to the states. And, you know, I think these guys are, you know, to be honest, I think mostly they were trying to, let's go back to 1776, mostly they were trying to put together in the spring of 1776, a kind of platform of action that would prepare the emerging United States of America for an ongoing conflict. So that meant the states had to resume legal government and not get rid of the revolutionary apparat, which had operated since 1775. We had a draft Articles of Confederation in part to, make palatable, comprehensible the authority of the Union, but also I think as a major part to attract interest from France. And the third committee appointed was the one that John Adams basically did to come up with a plan of foreign treaties. So that was, that's not stakeholding in the narrow sense. That's stakeholding in the sense when the Articles were drafted, what were the main policy objectives that had to be fulfilled. So we had to get legal government up and running in the states. We had to do something analogous, not legal in the robust sense of the term, but to make sure the Confederation actually has some kind of bona fide visible existence. And why do we have to do this? Well, we can't win this war without French support, and the French are not going to rally to our side if we don't demonstrate our own viability and sustainability, and if we don't, and if we don't kind of provide a victory to give them the incentive, to come in and assist us.
Just briefly, I could say, there was just a whole new generation of people who then become involved in politics over the course of the 1780s. And so names that are familiar to us, people like James Madison and Alexander Hamilton, take on a larger role at the Constitutional Convention. And names like, say, John Dickinson, who I mentioned earlier on in the talk, or Thomas Burke, who Jack mentioned, or Roger Sherman. These are the towering figures of the early 1780s. So we end up with a group of individuals who had experience in national politics, and that's how at least one reason perhaps, in the ways in which the Constitution and the folks who are there at the convention are different from the people who were there earlier in the decade.
I think one more question. In what ways is faith still key to sustaining our system of government, a civic faith? And at a time when we're seeing declining trust in our institutions, does history offer lessons for how to keep that faith alive?
So the founding generation was, I think faith is the wrong word, because the one persistent theme of this generation is suspicion and hostility toward government officials, a feeling that power corrupts. And so it was important not only to establish frequent elections and rotations of men in the offices, but also constant vigilance in case what this generation considered the inevitable would happen, which is that people would try to accumulate more and more power. So it was not so much faith in the government or even in the Constitution to maintain the government. It was taking seriously the power and the responsibility of the people to maintain their own freedoms. That's what happened in the Revolutionary War, and that's what you see in the early Republic.
Anyone else like to? Yes.
I think that at a moment like the one we're in right now, faith does matter. I think we've lost faith, but we haven't just lost faith in our institutions, we've lost faith in each other. And I think it's right that part of what defines the 1780s, and in fact all of American history, is a suspicion of government. But what enables, the question is, what enables people to overcome that suspicion and work together? Because there's never been a moment in American history where the people have all agreed. There's never been a moment in American history where we haven't had the problem of pluralism. There's never been a moment of American history where we haven't had inequality. But there have been moments in American history where we've been able to overcome them. And today, part of it is we've lost a sense of ourselves as a people. And one of the things the Constitution did create, and this is both the challenge and the problem of living in a very large republic at a continental scale, was a nation. And a nation is a group of people who see themselves together. And we may not have had that sense of nationalism had there not been a national government to which we were voting for direct representatives and where there were a judiciary acting directly upon us. In other words, where we became stakeholders in that government in a way we're not, for example, with the United Nations. That in a way is a kind of parallel to Continental Congress under the Articles. And so if we lose the faith, not just in popular self-government, but that the civic faith that we are a people with good intentions, and we start to see ourselves as distinct, then our institutions become unworkable. And we're starting to see some of that now. So I think the question becomes, how do we recreate that faith? How do we, how do we start to see ourselves as engaged in a common project, a common Republican project again? Is it through increased participation in local civic institutions? Is it by some of these other solutions of devolving power? Is it something else that brings people together across what are increasingly becoming mostly cultural divides? And so I think that's a really good question, because somehow without that faith in our systems and each other, we're not going to sustain them, and then we'll lose them.
So I'd like everyone to just bring us home with one thing you would like the audience to walk away from today, and I'll just go down the line.
So,
no pressure.
no, the one thing I would say, a lot of these problems, I was reflecting on Johann's remarks just a moment ago, that you might perceive to be a part of American society today, they have their analogs in the past. And there are different ways in which people navigated them at that time, and people will navigate them, and I'm optimistic that we will do so in our time today.
Yeah, I guess I want to echo that. That I think the one thing I would want us to take away is that this really was the 1780s was really a crisis time for the United States. And the solutions they came up with had their flaws, including the compromises over slavery, including perhaps the way they structured the legislature. But they were solutions to specific problems at the time. And so what I ask is, as we look at our problems of the time in the spirit of the framers of the Constitution, how do we solve them? Like, these were problem solvers, and they weren't writing in stone. They were writing ink on paper to respond to the very particular issues that were facing the United States at the time. And that if we approach them and ourselves that way, maybe we can start to do the same.
Professor Peterson.
Well, I guess the most important thing to know about this period is that it was founded in the belief, in the audacious belief, that rule by the people themselves is possible. And the distinctions between the Articles of Confederation, the new Constitution, they're about how to best secure a rule by the people themselves, how to protect the people from irrational majorities while maintaining that popular authority, and where specifically the people's power could be momentarily lodged in government, where it would be least dangerous. That was the project. How can we allow the people to rule themselves? How can we rule ourselves? Which in a world of monarchs was really special. And it continues to be the theme of our government. We engaged in civil war over which people are part of that polity, or which values do the people support. And it is as important now as ever to make sure that rule by the people doesn't fade.
Professor Rakove.
Well, I spent the last 55 years thinking about the origins of the American Republic, and I still find I have new questions to ask, and new problems to deal with, and new things to worry about, and I think a lot about what they got right and what they got wrong, starting with the equal vote in the Senate and the Electoral College, but that's a subject for another day.
Thank you. Well, thank you to our wonderful panelists for the conversation today, and to the audience for all of the excellent questions. I'm sorry we weren't able to get through all of them. We're going to break now for lunch and then reconvene to hear a keynote address from Representative Jamie Raskin. So again, thank you to our wonderful panel.
Hey, thank you. Thank you, thank you. Wow. I appreciate that. A standing ovation at the Constitution Center, that's like a dream come true for me. Thank you for that warm welcome. I'm thrilled and delighted to be with everybody today. I wish I knew everybody, but I'm delighted to meet you guys, and I'm going to try to stay for the next panel. Unfortunately, my schedule's kind of crazy. Back when I was an academic, I lived for conferences like this, and I would not miss a single panel, and I would spend weeks getting ready with a paper rather than trying to scribble out my thoughts on the Amtrak. The truth is that I've been puzzling over the questions presented at this conference for a few weeks, ever since I had the chance to start to think about it. And there are some fascinating philosophical puzzles that are created by the question here. And so I just want to lay my cards on the table that I arrive with a lot more questions than I do answers. And so I came to get some answers, and I hope at least when the Brennan Center, I think this is going to be published as some kind of law review symposium. Is that right? I hope it will. Well, anyway, I hope somebody will send me the answers when it's all over, whether it's published or not. I'm always delighted here to be at the National Constitution Center with my friend Jeff Rosen, the president. He's someplace out there, I think. I saw him briefly. Thanks for doing such a great job for the Constitution Center, for Philadelphia, for America, in creating this incredible space, this incredible forum and think tank about the Constitution with its remarkable feng shui for constitutional ideas and values coursing through the place. And thank you for arranging for such beautiful weather in Philadelphia, too. I mean, it's a lot hotter down in Washington, although there it's not just the heat, it's the stupidity, as you know. When I started thinking about the provocative premise of this conversation, I started by asking myself whether the Articles of Confederation are relevant at all to the interpretation of the Constitution, as opposed to its historical appearance and understanding. Obviously, it's part of the dynamics of history, but is it relevant to what judges and lawyers do? Is it relevant to the interpretation of the Constitution? After all, the Constitution is supposed to be a complete and self-contained document unto itself, and we like to think that the answers lie within the Constitution, or to the extent we go outside of it to the Articles of Confederation or the Articles of Association or the Declaration of Independence or the original state constitutions or the Magna Carta or any other written text, are we essentially fishing for evidence that's going to support whatever particular interpretation that we want to torture out of the Constitution or we want to find there? Or does it actually help us arrive at some kind of objective, determinate meaning of the Constitution? And that's hard to know. You know, it's hard to see exactly. I guess, you know, the best argument for that kind of extrinsic textual evidence usually comes from a dictionary. That was certainly Justice Scalia's claim, that if you looked at the dictionary that was in use at the time that a certain constitutional provision was written or a constitutional amendment was added, that would give you a sense of the original understanding of the language and therefore an original understanding of the text as adopted. If you go outside of that to other legal documents, even those in the chain of political custody of the United States, like the Articles of Association, Articles of Confederation, there are a lot of problems that come up. If we're looking for a word that was originally there that was omitted, does that indicate a kind of rebellion against that word, a departure from that word? Or does it indicate that that word or concept was just taken for granted and should be assimilated into the Constitution? And so you see when you're in an actual case or controversy how an omission can be played one way or the other. Even with the continuation of particular language from the Articles of Confederation to the Constitution, the continuity of words, which might seem to indicate a continuity of legality, could be altered according to the context within which the language appears now in the Constitution. Does the context actually alter that original meaning? Again, suggesting that maybe the meanings are ultimately opaque and inscrutable and indeterminate, and that juxtaposing the Articles of Confederation with the Constitution doesn't necessarily give you much analytical mileage. and rather generates competing arguments that have a certain kind of structure to them, but that ultimately it doesn't answer the question for you. And so then I began to think, okay, well, maybe the utility of the Articles of Confederation is not so much in terms of a specific interpretive methodology or technique, but becomes useful for us in terms of thinking about the whole structure of the government that was put into place. And so that, I think, may give us some more fruitful lines of inquiry. And again, this is at a more abstract or conceptual level, but it's still rooted in the language of the different documents. So the big difference that I can find, well, before I get to the big one, let's take this medium-sized difference. There's no president in the Articles of Confederation. There is a president in the Constitution. Now, what does that indicate? From a pro-presidential line of argumentation, it would suggest, therefore, we knew we needed a president, and the president's powers should be interpreted in a robust way through the prism of the appearance of Article 2 in the Constitution. Or, alternatively, somebody more closely identified with Article 1, like me, a member of Congress, might say, well, the presidency was added only as a matter of necessity. The presidency was still subordinated to Congress. After all, Congress is in Article 1, which sets forth all of the powers of the Congress. It appears right after the preamble of the Constitution. You know, even when you get to Article 1, Section 8, Clause 18, and all other powers necessary and proper to the execution of the foregoing powers, the so-called sweeping clause, which sweeps in all other kinds of powers. And then you get to Article 2, four short paragraphs. The most important of them may be a president shall be impeached for treason, bribery, and other high crimes and misdemeanors. And, you know, what is the core job of the president through the prism of Article 1 power, and there not even having been a president in the Articles of Confederation? Well, after Commander-in-Chief of the Army and Navy, not Commander-in-Chief, by the way, of the nation, not Commander-in-Chief of the government, but Commander-in-Chief of the Army and Navy in times of actual conflict, what's the core job of the president after that? Well, it's to take care that the laws are faithfully executed. Right? We've come a long way from those days, right? Take care that the laws are faithfully executed. So from that perspective, the appearance of the presidency is indeed to instill efficiency and vigor and energy in the implementation of the laws adopted by the representatives of the people, but nothing more than that. And I don't know that the existence of the Articles of Confederation and the non-existence of a president in the Articles of Confederation tells you much more, right? Wittgenstein says that language must speak for itself. And so you have to look to what the language actually says in Article 2, and we have to try to figure it out from there. So I was feeling a little dispirited, a little deflated about what the importation of the Articles of Confederation might mean generally for the conversation, except that I came to what I thought was kind of the big structural difference, which might give us a different gaze or perspective for reading the Constitution. And that is the fact that the Articles of Confederation were very treaty-like. They were very much a treaty or an agreement among the states coming together. So if it had been written in an exactly parallel way, it would have started off, we the states. And it was all about the powers and the prerogatives of the states and how the states remain sovereign and so on. And it was all about keeping state power from this league of states that, you know, might get together, this confederation, and do something different. But The shift over to the Constitution is dramatic in terms of thinking about constitutional sovereignty, because it does begin with those three magic words, the most beautiful words in the Constitution. Maybe the three most beautiful words in the English language, we the people. So it rooted the whole constitutional experiment in this idea of popular sovereignty, the sovereignty of the people. Now, if you think of it like a political scientist would, that's of course mitigated or complicated by virtue of the different ways in which states do have their own sovereignty within our constitutional regime and structure. But nonetheless, I think that we the people gives us the proper gaze and perspective to read the other provisions of the Constitution. Now, I took one, which is of some contemporary, indeed I should say some daily significance today, which is the Emoluments Clause, right? Now, the Emoluments Clause actually exists in the Articles of Confederation, if you guys have been studying your Articles of Confederation. And it's in Article 6, and it says, no state without the consent of the United States in Congress assembled shall send any embassy to or receive any embassy from or enter into any conference, agreement, alliance, or treaty with any king, prince, or state, nor shall any person holding any office of profit or trust under the United States or any of them, except of any present emolument, office, or title of any kind whatever, from any king, prince, or foreign state, nor shall the United States in Congress assembled or any of them grant any title of nobility. Okay, it's very similar to the comparable paragraph that we get in Article 1, Section 9, Clause 8. But it differs in some ways which I think go to this question of who's the sovereign. So here's what our paragraph says in the Constitution. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, except of any present emolument, office, or trust, or title, of any kind whatever, from any king, prince, or foreign state. All right, so when I bear down on that, what do I see? The Emoluments Clause, the Foreign Emoluments Clause, in the original Articles of Confederation was really about making sure that no state would stab the Treaty of States, the Confederation of States, in the back by making deals with foreign princes, kings, and governments. So it was about maintaining that horizontal unity of the states against somebody breaching it by going and cutting a deal with the King of England or somebody in France or what have you. Now, if you read our clause through the prism of popular sovereignty, it looks much more to me like it's about not allowing the president or members of Congress or anybody else holding an office of profit or trust under the United States from breaching fiduciary duty with the people, right? So no title of nobility shall be granted. We've got no kings here. We have no princes. We have no queens. We have no czars. We have no emperors. And nobody holding an office of federal profit or trust shall, without the consent of the Congress, that's introduced, that didn't exist in the Articles of Confederation original, except of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. We don't want the president or the Congress to be corrupted by foreign money, presents, offices, titles, or jet planes. Okay, so those of us who aspire and attain to public office under our Constitution are nothing but the servants of the people. And the moment that somebody gets into office and begins to think that he or she has or deserves or commands a title of nobility, of king or prince or czar or emperor or what have you, that is the moment to evict, eject, reject, try, impeach, convict, and start all over again. And that's where I think the neighborhood of surrounding principles becomes so important, and why ultimately, why these little clues may have some significance if you're lucky. Every once in a while you can find a diamond in the rough perhaps, but generally, I'm kind of with Wittgenstein on this, language must speak for itself. And the fact that we do have an impeachment clause is enormously telling. Sometimes my colleagues, not just across the aisle, but sometimes my best friends in Congress like Nancy Pelosi, they'll get up and they restate this 5th grade dogma that we have 3 co-equal branches of government. Well, first of all, co-equal is not even a word, okay? That's the first problem with that claim. The second is, why did James Madison say in the Federalist Papers that Congress is the predominant branch? Well, we just had a revolution against monarchy. We overthrew a king. The framers understood very well how a president, one chief executive, could come to think that he or she is the smartest person in the world and should dictate to everybody else. So yes, I think we were much more afraid of a president becoming a king than a Congress becoming a group of kings or nobles, because after all, we have the separation of powers. Now, you know, the separation of powers was used once. That phrase was used once in the Federalist Papers, and it was not about the separation between the legislative and the executive, or the executive and the judicial and legislative. It was between the House and the Senate. It was bicameralism that separation of powers referred to. So sure, there's a checking and a balancing of all of these different institutional points of power within our regime. But I think that we began with the proper fear of a president becoming a mad king, like King George was. And that's why we have so many provisions hemming that in. By the way, not just the Foreign Emoluments Clause, but the Domestic Emoluments Clause. The Domestic Emoluments Clause says the president is limited to his salary in office and may receive no other emoluments, payments of any kind, whatever, from the federal government itself, which includes the Secret Service, which includes the Department of Commerce, the Department of State, all of these agencies and departments which spent millions of dollars during the first Trump administration, and we don't have any accounting now of what is going on yet. But of course, we're on to bigger and better things, because the millions of dollars that flowed in from China and Saudi Arabia and Indonesia and United Arab Emirates and the Secret Service and the Department of State and the White House to the Trump hotels and the Trump International Hotel in Washington, which I call the Washington Emolument, and to all of the golf courses and so on. All of that is small potatoes compared to the vast new channel for foreign government money flowing in to the White House today through cryptocurrency, which of course is another conference of its own sometime. But that, the development of the presidential meme coin and cryptocurrency means that foreign states and powers can, without any tracing at all, dump not just millions or tens of millions, but hundreds of millions or billions of dollars into the presidency without any regulation, without any legislation, without any detection at all. Well, I'm straying a little bit too far right now from the Articles of Confederation. But I do believe that this is a useful exercise in terms of us thinking about what interpretive mileage there can be in specific cases, but even more importantly, in terms of the character of the different political regimes and governments that were created by the Articles of Confederation, or Association for that matter, and by the Constitution. And I do believe that we have a government that was created for the people and by the people, and all of us who hold office are servants of the people. The Constitution is designed in that way. The people have the freedom of speech and the freedom of press and the right to petition government for redress of grievances, the right to assemble, all of those things establish the active political sovereignty of the people over the government. And that's what we need to hang on to at a time when all of those things are under attack, as well as the separation of church and state. Maybe I'll close with that, because I don't know that that appears in the Articles, but it definitely appears in the Constitution. And sometimes I think that was the great breakthrough of the American Constitution. Our founders were Enlightenment liberals who broke from centuries of religious warfare between the Protestants and the Christians in Europe, and holy crusades and inquisition and witchcraft trials, and they wanted to put all of that behind us and to say that the freedom of worship and belief was something that would be left to each person and his or her God. As Madison put it in his famous remonstrance against religious taxation in Virginia. And government would be a place where we would try to base things on facts and data and empirical inquiry and reason. So I'll leave you with the words of some of the great democracy champions that I've held very close to my heart through this period. One, the great Thomas Jefferson, filled with contradictions, of course, but somebody who was an amazing champion of the First Amendment and free speech and democracy. And during the period of the Alien and Sedition Acts, and specifically 1798, the Alien Enemies Act, which has come back into vogue recently, Jefferson got a letter from a friend of his named John Taylor, who was complaining about the condition of the country. And he was saying, well, is this the same country where we just overthrew the kings and queens, and now we're rounding up all of the dangerous subversive Frenchmen and kicking them out of the country and arresting newspaper editors in Vermont and everything? And Jefferson wrote back, he said, "A little patience and the reign of witches shall pass over. Their spells dissolve, and the people recovering their true sight restore their government to its true principles. In the meantime, we're suffering all the horrors and malignities of the current period. But if the game runs against us sometimes at home, as it will, we must have patience, because this is a game where principles are at stake." There's a message to you from Jefferson in the 18th century. I'll quote one of my heroes from the 19th century, the great Frederick Douglass, who was born about half hour from my house at the Wye River plantation into slavery. And he escaped from slavery to become our great freedom fighter through the Civil War and the Reconstruction. And he was someone who never gave up on the Constitution, even when other abolitionists had. And even when other abolitionists like Wendell Phillips were burning the Constitution, he said no. The way that he read it, the Constitution was a charter of freedom that forecast the end of slavery in a number of different ways and was on the march towards a more perfect union. But anyway, Douglass said, if there's no struggle, there's no progress. And the struggle may be moral, it may be physical, it may be moral and physical, but there must be struggle. Power concedes nothing without a demand. It never has, and it never will. And I'll leave you finally with the words of the great Tom Paine, who got over here in 1774, 2 years before the American Revolution. He fell in love with the promise of America. He said, if this nation lives up to its values and ideals, it will become an asylum to humanity, he said. Not an insane asylum, mind you. An asylum to humanity, a place of refuge for people seeking freedom from political and religious and intellectual persecution all over the world. And he wrote the pamphlet that ignited the American Revolution, Common Sense, by which he meant all of us, if we're lucky, have 5 senses and a 6th sense, a common sense, a sense we have in common if we're willing to reason together without dogma and superstition. But anyway, that was a tough year, 1776. I'm reading an interesting book about that right now by the Texas historian H.W. Brands, the book is called The First Civil War. And it's about how the American Revolution was really a civil war, a war at home, because half of the people were running around saying, you can't beat the greatest empire that ever existed. You can't dethrone the kings and the queens and the emperors and the czars for all of human history, people have lived under people like Vladimir Putin and Viktor Orban and Kim Jong-un. That's the fate of humanity. And half of the people said, no, let's give this a try. Let's pledge to ourselves our sacred honor, our property, our very lives, in order to establish government that rests on the consent of the governed in pursuit of life, liberty, pursuit of happiness, the unalienable rights of the people, the protection of the rights of the people, all of whom we would interpret them to be saying, at least today, are born equal. But anyway, so Paine wanted to write a pamphlet to give people some hope, some courage, to embolden them during a very dark period. And he wrote this beautiful pamphlet called The American Crisis. And I'm going to just quote a little passage for you, but I want to update it pursuant to strict instructions from Nancy Pelosi, because she said that Paine was a feminist, and that he wouldn't mind. So, and he was fighting for women's voting rights in the 18th century. But anyway, Paine said, these are the times that try men and women's souls. The summer soldier and the sunshine patriot will shrink at this moment from the service of their cause in their country. But everyone that stands with us now will win the love and the favor and the affection of every man and every woman for all time. Tyranny, like hell, is not easily conquered, but we have this saving consolation. The more difficult the struggle, the more glorious in the end will be our victory. So let's make that victory ours in our century. Thank you very much, and thank you, Brennan Center, and thank you, Constitution Center. Thank you, everybody. Thank you so much. And I can't remember, I think we're doing some Q&A, is that right? Who's in charge here? Is it Jeff Adam? Oh, we're not doing Q&A? All right, thank you very much, everybody. I'll see you.
Good afternoon, everyone. It is hard to follow such a compelling and galvanizing speaker, but I will try to be as exciting as the congressman was. So panel one, we spent so much time talking about the Articles and why they failed. And among their numerous failures were representative issues, taxes, lack of coercion from the federal government, and an inability to really coalesce around issues of national importance. So coming out of, actually I'm going into the first question. I should actually introduce the panelists. First, we have Professor Kermit Roosevelt. He is at the University of Pennsylvania School of Law. Next to him, we have Professor Gienapp, Jonathan Gienapp. He is a historian and law professor at Stanford. And last but not least, we have Dr. Cost, a historian and non-resident fellow at the American Enterprise Institute. Back to the question. So coming out of the Articles, dealing with great distrust for centralized power, dealing with a body politic that was agitated by centrality of power, how did the framers of the Constitution, the individuals that wrote it, convince the American public to give the central government even more power?
Well, so I think that the failure of the Articles was pretty evident to people. So, you've got elite opinion and you've got public opinion, but you've also got just sort of the material conditions that people are facing. And I think, Shays' Rebellion brings home the extent to which you don't have a national government running things within the United States. And conflict between states, there's actually a brief war between Maryland and Virginia over oysters. The inability of Congress to tax and to support an army. All of this, I think, made it pretty clear to the general public that there were problems. And then the question is, what form will the solutions take? And one of the things that we're talking about, I think, is the extent to which the Constitution builds on rather than just replaces the Articles of Confederation. You know, and I think one of the reasons that the Constitution was easier to sell was it wasn't a repudiation of the Articles. So, you know, the revolution, that's a repudiation of monarchy. They're like, there's something fundamentally wrong with our governing system. We've got to change it drastically. I mean, you could say they weren't rejecting the legitimacy of monarchy as an idea. You know, if you had a monarch who did protect your natural rights, that would be okay. The problem was it didn't work out. You know, King George is a tyrant. We don't trust kings anymore. We're going to do it differently. But the relationship between the Constitution and the Articles of Confederation is not a repudiation in that way. And you can see that in a couple of ways. One, they preserve debts going forward. So they're saying, we had the Articles of Confederation, didn't quite work, we're going to change it, but we're still the same United States. Debts that were incurred under the Articles are good against this new constitutional government. And also they say, you know, it's a more perfect union. We're not rejecting the Articles, we're just improving on them. And maybe sort of the simplest way to explain that, I don't want to go on for too long, but is to say that with the Articles of Confederation, they understood we're 13 United States, and being united means we have to sort of speak with one voice in some capacity. And basically that's the outward-facing sovereign, international relations. So the states aren't going to declare war on their own. If the United States is at war, we're one nation, effectively. They weren't a nation, but we're a confederation, but you know, we're all going to be working together. And then what they realized with the failure of the Articles was they needed more of an inward-facing national sovereign too. So they needed a national government that could give you uniform laws on some topics and that could stop the states from fighting and that could make it more of a union for domestic as well as international purposes. But I think a lot of what was going on was this sense, you know, we're improving things. It's not another revolution, even though it is illegal, right? It violates the Articles unanimity requirement. But it's not a rejection of the prior order, it's an improvement.
So first I'll just say what a pleasure and privilege it is to be here. It's always wonderful to be at the National Constitution Center and continue my collaboration with the Brennan Center that is now several years long. So to the question of sort of what's on people's mind in 1787 and how are they trying to sell it, I think sort of front and center is the idea that this federal system that has emerged in the wake of the Declaration of Independence lacks the necessary energy, and in two distinct senses. So the first one is the relationship between centripetal and centrifugal force. So the way to think of this is you have separate states, you have these collection of things on the periphery and something in the middle that's trying to hold them together. The analogy they often use, they use it a lot at the Constitutional Convention, is thinking of the federal system like a solar system. How do we have the right gravitational pull toward the center such that the parts don't fly off? And this had been the deficiency of most confederacies through history. Centrifugal force had been much stronger than the centripetal force, and therefore the parts broke apart and you got disunion. So how do you concentrate more energy at the center to hold the whole thing together, to think of it as a system that will actually work and not constantly be at war with itself? Well, part of the way you do that is the second way in which you need to endow this system with energy, which is give the national government more of a capacity to do things. This has been a major problem both during the war and thereafter to address the problems coming out of the war. Very little executive capacity to actually act and address these emergent problems. So one thing that was really necessary is, as we were talking about in the first panel, we have this sort of anomalous single-body government, more like a diplomatic body. We need to replace that with an actual genuine government with 3 independent branches that look like the state governments that also have independent authority to act. So it doesn't all run through the states. So it either represents the people directly in some fashion and is legitimated by the people directly in some sense. Only that can give the federal government the energy needed to act and address problems that are emergent that will sort of hold this system together. But they often thought of how they were building or refining a system and presented it to the American people that way, as opposed to writing a legal code. You know, we're trying to build a system that is going to have at this point, 13 states and 1 union, and how are we going to ensure that the 13 don't rip apart the 1?
So I would say the salesmanship of the Constitution to the people is one of the most brilliant political maneuvers in the history of the United States of America. And I would point out at the outset that the message calling for a federal convention did not call for a new constitution. It called for a reform of the Articles of Confederation and a revisal of them to make them adequate to the exigencies of the Union. Well, what exactly does that mean? Well, this is where a handful of what you could call nationalists, or who would later be identified as Federalists, seize the initiative and set the agenda of the Constitutional Convention. This is particularly evident in James Madison in his efforts in the winter and the spring of 1786 into 1787, helping to create a system of government known as the Virginia Plan. And Madison comes to Philadelphia early. He comes at the beginning of May in 1787. The convention didn't get a quorum until the end of May, so he's coordinating his actions with the other delegates from Virginia and possibly the Pennsylvania delegates as well. And so when the convention opens, Edmund Randolph says, here, let's talk about this plan. In this plan, the Virginia Plan was not a revisal of the Articles of Confederation. It was a complete elimination of them. It was basically a do-over. And what happens throughout the next couple of months is they edit and they debate and they revise and they re-revise. But that initial seizing of the agenda and orienting the convention towards drastic reform rather than something more modest is really important to understanding what happens. And then on top of that, the convention is debating in private, in secrecy, which is for the most part maintained. And then in September, here is this document. And I would say that there's a couple advantages that they had. The first is the United States Senate. The United States Senate is an incredible incentive to the small states. Thinking of Connecticut, Georgia, although Georgia's territorially large, it's small in population, Maryland, Delaware, New Jersey. This is an incredible bargain for the small states. To have all of the securities of a national union combined with protection in the United States Senate. So it rolls through ratification in large measure because of these small states. And finally, it doesn't really hit a snag until Massachusetts, but by that point, it's already picked up so much momentum. And Madison, in the Federalist Papers, says, this is the argument that we're facing. You imagine you're a sick patient. You're sick, and you're going to die. And there's a doctor who says, this is what you need. And there's another doctor that comes in, somebody else comes in and says, oh, no, that'll kill you. Don't do that. Whatever you do, don't do that. And the patient says to this other doctor, oh, what do I do? And he doesn't have an answer. And so what's the only reasonable choice is to do the doctor that offered a prescription. And indeed, I think this is another feature here as well, which is that those individuals who would become what we know as the anti-federalists are not meaningfully taking part in the convention. I mean, there are some there, like Luther Martin, but the two Clintonian delegates from New York, they leave. Patrick Henry doesn't come. And so you don't really see meaningful anti-federalist movement really until opposition to the Pennsylvania's ratification of the Constitution. And so really what you get then is, in theory, the country, I think, might have accepted something like the New Jersey Plan if that had been presented. But the nationalists, the federalists, seized the initiative such that what was presented to the country was the Constitution.
Thank you all for that. Following up on a thread from panel one, we spent a lot of time talking about the importance of localism, republicanism, and it made me think of this concept that was raised during the Constitutional Convention debates, the concept that a state precedes any constitution, and therefore the state is completely independent and can operate in a way that might be different than the federal government. But then I read the preamble of the Constitution, and thank you to Professor Gienapp for recommending that, which says that we, the people, create a united states, right? So in the first opening words of the Constitution, we're repudiating that idea. And so I'm curious, thinking now to various constitutional arguments regarding the scope of state power, what does the preamble tell us about the concept that a state is or should be sovereign simply because it existed temporally before the United States Constitution?
Well, I think that's a very interesting question. I mean, that's one of the perennial questions of our constitutional history. What's the relationship between the nation and the states and the people? And because it's one of the perennial questions, I would tend to say this is something that people fight over. This is something that inevitably we're going to fight over, and there is no definitive resolution. And then sort of as an illustration of that point, I'm going to say, okay, let's look at the preamble. What does the preamble say? It says, "We the people of the United States." Okay, so that certainly does sound like here we've got a single national people who are the ultimate sovereign, creating the Constitution, and wow, the states are sort of cut out of it because the power comes from the people. But if you go back and look at how it was actually drafted, it did say, "We the people of the United States of Rhode Island and Providence plantations and North Carolina, Massachusetts." And they listed them all. And that makes it sound more like it's the people in the states, and now like the states are sovereigns. They took out the actual enumeration of the states because stylistically it was awkward, and it would be embarrassing if some of the states refused to ratify, as of course Rhode Island initially did. So even there in the preamble, I think you've got this fundamental ambiguity. And I think that a lot of my growth as a constitutional law professor has been realizing that there just are fundamental ambiguities. There are things that people did not agree on at the time. I used to sort of think of the Constitution as this secret code, sort of like Nicolas Cage, National Treasure. If you can figure out what the mystical incantation and cipher is, then all of the right answers are laid out before you, and it's objectively true, and you're just correct. And I don't think about it that way anymore. I think that there are issues that people argue about, and they resurface again and again in different guises. And some of them are just focal points for disagreement, which I think is not necessarily a bad thing, because a lot of these issues, the American people get to work them out. And we've got vague and poorly defined concepts in the Constitution, and the American people, through ordinary politics or just the ordinary interactions of ordinary life, get to sort of define our constitutional values and figure out what equality means to us, or how the nation and the states should interact. There's a lot of interesting history to be discussed. So the states, Abraham Lincoln said, didn't precede the Union because it was Congress that told the states, write your constitutions, now you're states, you're not colonies anymore. That's true. The states did certainly precede the Constitution, and under the Articles of Confederation, they do seem a lot more like independent sovereigns. Before the Articles of Confederation, after the Declaration of Independence, they are fully national sovereigns with the power to make and conclude war, and all of the things that states may of right do. So they start out as full international sovereigns. They surrender some of that sovereignty. They accept some restraints under the Articles. They accept more restraints under the Constitution. But this whole question of who's the primary sovereign in the American system, and sort of do you trust the states more, or do you trust the national government more, that question will never go away. And also, I think, one of the reasons that we're more interested in the Articles of Confederation now than people were in, say, the 1960s with the Civil Rights Movement, is that over time, who's the good guy in the American system, that changes. So, sometimes the states are the good guys, and they're standing up against the national government. That's the revolution. Sometimes the states are the bad guys, and they're standing up and defending slavery. That's the Civil War. Sometimes we like Congress, Reconstruction, Congress versus Andrew Johnson. Gee, I like Congress there. Sometimes you like the president, maybe. Sometimes. But ultimately, I do think the ultimate sovereign is the American people, and I think ultimately the American people have to decide how to make the system work the best they can, or if it's not working, to change it.
So building more or less directly off of those very nice remarks, I mean, in many ways, this is the question. Before you figure out how to govern yourselves at the time of the revolution, you have to answer the question, what is the United States of America? Who are we? And it's not an easy question to answer, because some people emphasize the unity of the nation and the American people together, and others say what we definitively are a set of more or less autonomous individual states, different kinds of peoples that are going to confederate together, come together under certain kinds of agreement. And this hinges on competing interpretations of the Declaration of Independence that is ambiguous in this regard, because it, on the one hand, refers to one people, a collective that declared independence, but also talks about how it's establishing and therefore is speaking for free and independent states in the plural. So to figure out what the Articles of Confederation says and can do, and then what the federal Constitution says and can do, requires first answering this question. Who does it speak for? What kind of a political entity does it represent? The Constitution, as a form of government, presupposes the Constitution of the federal union itself. And the preamble is one of these sort of key touchstones that was purposefully written the way it was by leading nationalists, James Wilson and Gouverneur Morris above all, because they were really eager to make it clear that it is not we the states and it's not we the peoples of the United States, it is we the people of the United States, a single collective entity. And part of the reason why is because of what James Wilson, a leading nationalist who always emphasized the nation over the states, said in the convention when he had a very interesting debate with Luther Martin, a leading defender of states' rights, in June of 1787. Luther Martin says, the states came first, the chicken and the egg problem. The states came before the Union. We were put into a state of nature by the Revolution. The states created separate governments, and we then confederated. The states are primary. They came first. James Wilson responds by dramatically pulling out a copy of his Declaration of Independence and saying, you have it wrong. The Union preceded the states because we declared independence together. This is essentially a dress rehearsal for what Jefferson Davis and Abraham Lincoln will argue about in 1860 and 1861 about the origins of the Union. So if you ask someone like James Wilson or Gouverneur Morris or the other leading nationalists, they would say the preamble is proof positive that what underlies the US Constitution is our first Constitution, which is not the Articles of Confederation, but the Declaration of Independence that establishes a single nation, a single people. And this was actually how they interpreted the Articles, to suggest that the Articles gave the national government significantly more power than a lot of people thought. But they weren't alone. Other people had different views on this subject. Other people said, no, the Declaration of Independence created a multiplicity, not a unity. The Articles of Confederation, most important provision is Article 2 that says, each state's sovereignty, independence, and freedom shall be retained unless expressly delegated to the national government. And they would point to not the preamble, but the eventual 10th Amendment, which is among the things that the Anti-Federalists call for, which says that all powers not delegated to the federal government are retained by the states or the people. But then the nationalists like James Wilson would say, it says delegated but not expressly delegated. Because that is a callback and a reminder of what the preamble is alluding to, which is this nationalist reading of the Declaration of Independence. But there weren't easy answers to these questions in 1776 or 1781 or 1785 or 1787 or 1791. The United States devolved into civil war in the 1860s in many ways because there were competing answers to these questions. And as Professor Roosevelt was suggesting, those questions resonate still to this day. That was the first question, and in some ways it's still the question.
Yeah, so one of the things I like to tell my students is that politics is not math. So if you're bad at math, then maybe politics is the subject for you. And my reasoning here is that in math, 1 + 1 can only equal 2, right? It can equal nothing else. One is greater than 0. Two things have to be equal. Well, that's not really how it is in politics. I mean, you can look at our persistent debt and you can sort of see us collectively just ignoring the math problem there. But more than that, right? What are we? Are we a national union or are we a federation of states? These two things are very different from each other. And yet when you look at the Constitution, we're kind of both. right? And you can sort of see the push and pull within the document on matters like this. So you can see, for instance, the preamble, which was written by James Wilson and Gouverneur Morris, as being very nationalistic in the Committee of Style, right? But when John Rutledge produces the rough draft of the Constitution, he creates enumerated powers, right? He gets, the convention had preliminarily voted on essentially giving Congress plenary power to do whatever was necessary for the national interest. When the rough draft is produced, it's an enumerated power, which by implication means that the federal power is limited. You can look at the House and see a national union there. You can look at the Senate and see a confederation. Even the way in which ratification occurred, right? It was ratified by 9 states, which suggests a kind of confederation. But it was ratified by special ratification conventions elected directly by the people. Right? So it sort of swirls through the Constitution, this tension, and it swirls through our history. I mean, you can look at the Kentucky resolutions of Virginia and see that as a bold stab at limiting federal power. And you could look at the quids, the tertium quids of the 1820s, thinking back to the good old principles of 98. You can look at, on the flip side, you can look at Jackson's response to the nullification crisis, specifically citing the preamble, saying states cannot do this because they created a nation. And again, you can see it in the Civil War. You can even see it nowadays too, continuously. I mean, since the Rehnquist Court in the 90s sort of began using the 10th Amendment to strike down federal laws, it raises questions about the specific scope of federal and state power, which brings us back into this sort of almost an ontological question that doesn't admit of a clear answer.
So you all described ambiguities within the design of the Constitution that make it difficult to answer a question about, the scope of state sovereignty. I want to ask yet another confounding question that is very specific to Article 2. So, there are several theories about the scope of executive power that are supported by various statements that individuals made during the constitutional debates. And one thing that I found striking is, James Madison, that we all love to refer to, the father of the Constitution, he says, essentially, the executive is just a person. We have a person here that's going to execute the law. Clearly, his interpretation did not rule the day. And so I'm curious what you all believe that the constitutional debates say about presidential power. And, is our current model, where it seems like the president has sort of aggrandized a lot of power over the years, of course it's been given by the court, and in some senses Congress has delegated that power, but is the system of our presidency, is the way that it's working at all similar to the way that it was perhaps intended or envisioned to work?
So I would say, again, different people envision different things, and different people hoped for different things, and we've seen a bunch of different things happen. And I guess, one of the luxuries that we have now with the historical record that we have is we can look back and we can pick, maybe examples that we like and say, the president should maybe behave more in this way than in that way. But I do think that we should understand that the constitutional design has produced this accretion of power in the presidency in a couple of ways. So one is something that the framers certainly did intend. They understood Congress is a multi-member body. It's got 2 houses. It's a lot harder for Congress to act. So you do want to have some capacity in the government to respond with energy and dispatch, to handle crises, to get things done when necessary. That's the executive branch. The power is consolidated in one person. They did that deliberately. So the idea that you're going to have executive power concentrated in one person and that person is going to be able to be effective, that's part of the design. If you think about the president versus Congress, though, they anticipated, of course, checks and balances. That doesn't work out the way that they expected because of the party system, which sort of notoriously they didn't foresee. So if you've got 2 parties and they're fighting for control of the government and they're sort of relatively equal in the support that they command, what's going to happen? Well, one party will win the presidency, and that's the executive power concentrated in one person, wielded by that party. And then on the other side, you've got Congress, which is divided, and it's hard for Congress to act anyway. And we've got, you know, the filibuster in the Senate, which is not in the Constitution, but we've got all sorts of things that make it harder for Congress to get things done. It's sort of natural that the president is going to come out ahead in most of those struggles, because the president has not only sole control of the executive branch, but also a lot of allies in Congress, members of his party. So you can expect that the president is going to do pretty well when contesting with Congress. But all the same, right, we've got a lot of choke points and veto points in the system, and those are designed, again, in part, intentionally. Right? Separation of powers is supposed to protect individual liberty. You need all the branches to cooperate generally before the government can put you in jail. You know, Congress has to pass a law saying you can't do something, and then the executive branch has to prosecute you for doing that, and then the judges have to agree that you in fact did it. But again, once you introduce the party system, it turns out that all of these veto points in the system make it really easy for one party to stop the other party from getting anything done. So, you know, you win the presidency, but you've got these opponents in Congress. Maybe they can still stop you from getting something done. And then people start to think that the government is broken, and then they start being susceptible to the demagogue who comes along and says, I alone can fix it. So again, like, I think our Constitution, coupled with the party system, does bear some responsibility for the problems that we're facing now.
So as perennial questions of American constitutionalism go, certainly what kind of presidency was imagined at the beginning? How did people understand executive power at the beginning? Not least because the presidency has become this astonishingly powerful office across time. I think the way to sort of begin orienting this is American political attitudes in the 18th century were deeply shaped as, you know, living in the English-speaking Anglophone world and feeling as though they were, you know, as members of the British Empire prior to the Revolution, heirs of the English constitutional tradition, to the great constitutional settlement of the 17th century, which had been an epic showdown between the prerogatives of the crown, the king's ability to act freely and do as he wished, against the privileges of Parliament. And in the Glorious Revolution of 1688-89, it's been a decisive revolution that Parliament had prevailed, that the sort of king's discretionary authority would be cabined under parliamentary control and law. So to a lot of people in what was referred to as the Whig political tradition, which deeply informed American attitudes, an executive was simply that, a mere executive. President as errand boy. Somebody else provides the instructions, and the executive carries those out, carries out somebody else's will. So this is why in the state constitutions in 1776, that are initially written in 1776, the chief executives, the governors of the various states, have very, very, very little power, because it's seen as antithetical to Republican liberty, and it smacks of monarchy, of the worst kind of monarchy. What was the point of fighting a revolution? Just to concentrate executive power. We're going to have executives as errand boys. The legislature that best represents the people are going to design actual policy, and then the executive merely carries them out, sort of like a power of attorney. They don't have a free hand, they do as you tell. But the problems of the 1780s under the Articles of Confederation had led some people to think that this misbalanced things. They didn't necessarily repudiate the concern about executive power, but they thought that legislatures that had all that power, the impetuous vortex, as James Madison put it, they're able to pull in so much authority, can themselves become tyrannical. So you need to come up with new ways to potentially check them. And one advantage would be to fortify the executive in new sorts of ways, potentially by reviving what a lot of people in this political tradition thought was extremely dangerous, which in giving the executive things like a share of legislation, right, through a veto power. You know, this made the executive a part of the legislative power. So there were a lot of people at the Constitutional Convention who were very interested in that kind of presidency, a presidency that would not be extraordinarily weak and errand boy-like, like under the states, but would actually have independence and a free hand. And they really defended this view of the presidency, that there would be a veto power, appointment power, commander-in-chief power. There would be an ability to resist Congress and actually do things. But the other question is, did they mean things beyond that? Did they mean for executive power, what is vested in the president at the beginning of Article 2, to mean an enormous swath of power that would provide the president really an extraordinary amount of authority and independence? And I think a lot of them were interested in a very strong president from the perspective of the state constitutions in the 18th century, but did not have in mind the kind of presidency that has come to predominate. But they put in place a system that ended up creating the dynamics that made it very easy for the presidency and the executive, for reasons Kim was talking about, to pull it towards its orbit. Alexander Hamilton realizes this as day one as Secretary of the Treasury, that the executive branch has first mover advantage. And James Madison goes from saying, I thought the big problem in Republican politics was that legislatures pull in all the power and we're just trying to resist against that kind of concentration. Alexander Hamilton under the Washington administration has shown me that actually executive power can be really robust and muscular in a Republican system of politics, and begins rethinking how he thinks about these things. Because the president has a capacity to act through executive authority where Congress is mired in debate, and especially in foreign affairs. And the United States finds itself in having to deal with the wars precipitated by the French Revolution in Europe. Are we going to stay neutral, or are we going to get involved? And it allows the Washington administration to say, hey, we basically set foreign policy. We're going to take the lead on this. So the growth of presidential power was not necessarily anticipated or expected, even by people who thought it was really important. But in a lot of ways, it's right there in the system of what Article 2 unleashes.
Yeah, James Madison was certainly surprised in 1790 by the newly emergent power of the executive branch. As a matter of fact, in 1789, he had worked to actually beef up the power of the executive against what he continued to fear would be an overawing congressional influence. So, for instance, it was Madison in debates over the State Department. Does the president have the power to fire the Secretary of State? Madison was a leading advocate that, yes, that's inherent in executive power. Another and this is very ironic as well. It was Madison who sort of, like, some people were skeptical about having the Secretary of Treasury submit proposals to Congress on the state of the public credit, because they worried that that would be too much executive influence over Congress. Madison waved that away, and it was those three reports that Hamilton produced from 1790 through 1791, the first two reports on public credit and then the report on manufacturers, that the potential of the presidential agenda-setting power became evident to Madison. And so what you see then, as a matter of fact, a continuing debate, sometimes in the subtext, but often in the foreground, is between the two parties, is the scope of presidential power. This is one of the reasons, for instance, that Thomas Jefferson ends the tradition of given a State of the Union address to Congress, which had been done in person by both Washington and Adams. This is where you get the initiation from Jefferson up through Taft of a written State of the Union address to Congress to sort of push the president into the background. And I think another thing to bear in mind as well, when we're talking about inherent executive power, presidential power, I think you cannot underestimate the political importance of the democratized presidency. And the presidency in 1789 was not democratized. Now, for sure, there were some states that did have elections for, say, like electors. Virginia voted for electors. But it wasn't really until the 1820s and then into the 1830s where, with I think the exception of South Carolina, you have the entire country voting for president. And so you get this really remarkable twist of things. And a good illustration of this is when Madison is president and he's trying to sort of like work through the crisis with Great Britain, his attitude is, I have to wait and see what kind of tools Congress is going to give me to negotiate because Congress is the popularly elected branch. But then in 1830, when Andrew Jackson is president and he discovers members of Congress are opposing him, his allies, he says, send them home and see what their voters say for defying my suggestions. And so the democratization of the presidency is something that happens in stages. And it was democratized, but then almost as soon as it was democratized, it was sort of grabbed by these party organizations for almost 100 years that sort of constrained the presidency. But now the presidency is unconstrained really by the Electoral College or by party organizations. The presidential nominees are democratically elected. The presidential election is democratic. And so the president is able, in ways that the framers would not have probably imagined, able to claim the mantle of democratic tribune, right? Going back to ancient Rome, the tribune is the spokesman of the plebeians, right? And the president can say, I speak for the country. It's a very, very formidable political power.
Thank you. And just a reminder to the audience, if you all have questions, please write them down on the note cards on the table and hold them up so that we can address them. So I've got a handful of audience questions here. I'll start with this. Can you all talk a little more about the Constitution's fundamental ambiguities and how they relate to the country's current struggles?
Small question.
Small potatoes.
Well, I'm happy to I mean, there are two levels here. So one is the ambiguity of particular aspects of the Constitution, particular phrases. So for instance, Article 1, Section 8 establishes a set of enumerated powers, and certain people say, well, this establishes the sort of principle that the federal government will be of a different kind than the state governments. It will not have sort of broad governmental plenary power. It will have to work off of an enumerated list of power. But it's punctuated by the necessary and proper clause that says that Congress can also make all laws necessary and proper to carry out not just these foregoing powers, but all other powers vested in the government of the United States. So there's a central ambiguity there about what exactly is pulled in by this clause that comes at the end of the list. If somebody says, you can only do these 10 things, if you tell your children that, or you make a list and say, this is the list of things you can do, and you can also do anything else that is necessary and proper to kind of carry those out. That creates a lot of ambiguities. But there's a bigger ambiguity that's on the table, which is, what even is the United States Constitution, and how should we interpret it? Is it alike in kind to other sorts of things that we have some sense of how to interpret? Is it alike in kind to other sorts of legal instruments like statutes or contracts or treaties, or is it very different because it's a different kind of instrument rooted in popular sovereignty rather than ordinary law? Is it a document that's supposed to be, an instrument that's supposed to be completely finished in a sense, that it sort of speaks to all sorts of questions, if only through implication, or is it kind of unfinished by nature, sort of calling to either future generations to, it's just sort of the framework of a building, and it's to future generations to keep building it out in a big way? Or are things like the Article 5 amendment feature there, not just in case things need to be changed, but as a call to continue doing the work? The sort of big first question of its ambiguity. What are we even reading? What does it even mean to interpret and construe a constitution and carry it into effect? Is a big source of ambiguity that's never gone away. People often debates over specific parts of the Constitution are really being governed by big debates in the background about what it even means to have a constitution and to be bound by one.
Yeah, I actually want to follow up on that thread and go back to one of my questions. Sorry, audience, it's a personal privilege for a minute here. And talk about expounding, interpreting the Constitution. Professor Peterson, I'm not sure if she's still here, but she wrote a really great paper that argued, during the founding era, we interpreted public law equitably. And the Constitution is a public law document. It's not, doesn't have the prolixity of a legal code, as McCulloch said, I believe. And so in considering that, how should we interpret the Constitution, and is that fact, the equitable interpretation of a public law document, is that a rebuke of alternative forms of interpretation that might be a little more restrictive?
Well, so this sort of reminds me of what I was saying before about how early in my career I thought of the Constitution as a secret code that could be unraveled with the correct cipher and would reveal all of the correct answers. And then later, I started thinking of the Constitution and constitutional interpretation more as sort of paleontology. So, once upon a time, you could say the dinosaurs of original meaning stalked the earth, and now we're left with these bones and we're trying to reassemble, but there was really a dinosaur, and we're trying to reconstruct the skeleton in the most accurate way, but there is a right answer. And what I was saying before, I understand now as sort of a process of maturation as a constitutional law scholar, is the realization that really there was no dinosaur. There was no original meaning, objectively correct, answering this question that we're trying to reconstruct. We have resources that the past has left us, and those resources might foreclose some interpretations of some constitutional provisions, and they might make others more plausible. But fundamentally, we are engaged in a process of construction, I think. We are building a framework for our nation going forward, and that really should be the focus of what we're thinking about. So yes, we like the idea of fidelity to the past. I think Americans are very unusual, actually, in the degree of devotion that we have to this idea of keeping faith with the founders and the framers. And that's nice. It's part of our national story. But we should understand that this is fundamentally a creative project, and it's not an abstract intellectual exercise. It's an exercise in self-governance. It's an exercise in trying to create a nation that we can be proud of, that will function, and to which we can all belong going forward. So I tend now to think about constitutional interpretation less as an exercise where there is a right answer to the hard questions, that can be objectively proven. And I should say, I think that Justice Souter, for whom I clerked, was a big influence on me in this regard. Sometimes there are conflicts. Sometimes there are ambiguities. And it's a test of us to see that whether we can work through that in a way that allows America to work together. But it's also a vote of confidence in us as a nation and us as a people that the drafters gave us this document with these contradictions and these ambiguities, because they believed that we could do it.
Yeah, I think I view the Constitution predominantly as a political document, as creating a framework for politics to happen. And so when we're talking about the ambiguities inherent in the Constitution, I actually think in many ways those are its greatest strengths, because it creates a certain level of flexibility. And I would point out here that on certain issues, the Constitution is not at all flexible. If the Commonwealth of Pennsylvania were to elect a third senator to the Senate, that person would be denied entry into the Senate and say, no, you get 2 senators and you get 2 senators only. Right? Likewise, the government can't just not conduct a census in 2030. No, that has to happen every 10 years. Right? But the Constitution has these delightfully ambiguous phrases like the general welfare and interstate commerce. And then we added on to them with the amendments, right? Cruel and unusual punishment. And then later on with the Civil War amendments, what exactly is due process? And I think that this is, like, to sort of use the cityscape here, like if you look at Independence Hall down there, that is a building made of brick. And you can only make buildings of brick so high, because brick is very rigid. But all around us are buildings made of steel, and steel you can build higher and higher into the sky because it has movement to it, it's flexible. And I think that one of the ways that we understand the primary way, actually, I would argue, that we understand these wiggle words in the Constitution is through the process of politics, right? And you can see that in the history of constitutional debates. 175 years ago, the major constitutional debates had to do with whether or not the federal government could fund internal improvements. We don't have that debate anymore. Likewise, there was a heated debate over whether or not chartering a private corporation was a constitutional act. We don't have that debate anymore either. You could say, well, that debate was resolved in McCulloch v. Maryland, but I think that actually misses I think that misses the tail for the head. I think that the debate was actually resolved by the public, and what the court did in McCulloch was acknowledge the resolution of that debate. And so these words and these sort of ambiguities, these flexibilities within the Constitution, are determined and redetermined continuously, predominantly through the political process.
Thank you. Our next question is about amending the Constitution. So, you know, under the Articles, it was virtually impossible to amend because of unanimous consent. The Constitution makes it a little easier, but we have not amended the Constitution in 32 years. And many people opine that it's because our Constitution is actually broken. And so I'm curious what that says about our Constitution. Is that an indictment of the document that we cannot amend the people's vision of their government because of so many external factors? Does that mean our system is broken?
I would say no. I mean, I think our system is struggling. I certainly wouldn't deny that. But I would acknowledge the difficulty of what you could call dead hand control, right? A document that was, that claims to be we, the people of the United States, was written, debated, and ratified by white male property owners who have been dead for more than 200 years. There's definitely an issue of dead hand control in a constitution that is hard to amend. However, that being said, I would make 2 points, just at least in terms of considering the nuances of this. I think that one of the fundamental values embedded within the Constitution is the doctrine of consensus. This is the idea that how are the framers trying to solve the problem of majority rule? Because majority rule can be a problem. You can get majoritarian tyranny. And when you take the national republic and you take the system of checks and balances, you start to see this vision of how the framers went about solving, which is the idea that the larger the majority, the broader the majority, the more durable the majority, the more likely the ruling of the majority is going to be beneficial for the national interest. It's not a guarantee, right? Any given moment, the majority could be wrong. Absolutely, even a large, broad, and durable majority, the majority can be wrong. But over time, that's probably your best bet, right? And so when we come to consider changes to the fundamental law of the country, that should be where there is a clear consensus. And I think that is what the amendment process does. It creates a demand for consensus. And consensus, of course, is exactly what does not exist in our country and has not existed in our country for some time. So I think that is something to bear in mind. The other thing I would bear in mind as well is the point that I made to the previous question, which is that we have amended the Constitution many times without actual amendments, right? Like if you look at like the debate over the General Welfare Clause, or take even the interstate commerce clause and how that was reimagined during the New Deal. It was completely reimagined. And we de facto amended the Constitution when we elected Franklin Roosevelt, re-elected him in 1936. The public rendered their verdict on the New Deal, and the Constitution was in many respects changed.
So given that this is a conference on the Articles of Confederation, I'll start with there as essential context, because from the perspective of today, we often say, why did the people who designed the Constitution make it so hard to amend it? From the perspective of what came before, they would emphasize, we made it very easy to amend. The problem under the Articles was it required unanimity, every single state, and that was among the reasons a new Constitution was needed. They really thought they had lowered the bar in a significant way that would permit meaningful, necessary constitutional change when it was necessary. And this was among the many things the Federalists emphasized in the face of constant anti-Federalist complaints, that this new Constitution would extinguish the principles of the American Revolution. You're replacing local government with distant central government. It's not adequately representative. You've set up this unitary executive figure that will have all this power, this federal court system that will pull on appeals process decisions that were made at a local level with a local jury into distant federal courts. How could you have destroyed the revolution in this way? And they're trying to parry all these claims and explain how, in fact, actually what they've done will modify and refine the principles of the revolution. But one thing they come back to over and over and over and over again is, You anti-federalists keep saying the Constitution is imperfect. Of course it's imperfect. Nothing human beings can make is perfect. Nothing we could have made in 1787 could be close to that. How amazing that we've wired into the structure itself through Article 5 means for its own amendment. And some of this is rhetorical, but I also think some of this is a prediction that they think when change will be needed. When the exigencies demand it, the amendment feature is there and it will not bog down like the Articles. Now, as it's turned out, that really hasn't played out as that might have predicted, because again, we see it as much too high a threshold. State constitutions are amended all the time by comparison. It's much easier to change them. Some people would say, who live in certain states, it's much too easy to change state constitutions. So it's about finding the balance. I guess two things that could just then be said about sort of our defunct amending tradition. On the one hand, some would say, look at the early 20th century, the progressive era, when people really amended the Constitution. There was a culture of believing in doing the work of amending, rather than saying it's just about winning a majority on the Supreme Court because amendment's not possible. But the flip side of that story would say the most important amendments that kind of gave the United States Constitution a new lease on life were the Reconstruction amendments that were only possible under conditions that could never have satisfied the amendment conditions. It required a war and half the country being thrown out and the surviving winning majority reconstituting the nation by abolishing slavery and establishing new equal rights of citizenship and birthright citizenship and the like that never, ever, ever could have gotten through the amendment process. So there is a complexity there to work through. But the framers, they would have emphasized we had one standard and we made it way easier to amend. They definitely thought that they were creating a path to renewal that would not, this was one of the major reasons the Constitution was better than the Articles.
If I could just say one thing on that quickly. So I think the Constitution is too hard to amend. One of the things the progressives wanted to do, actually, one of the progressive amendments that didn't make it, was they wanted to make it easier to amend the Constitution. And it's absolutely true, as Jonathan was saying, the framers made it easier than it had been under the Articles. And they thought that they were creating a path towards renewal. But again, I think the party system has really messed this up. So the last amendment that we had was this very anodyne, good government, you can't vote yourself a raise before an election intervenes. You could expect bipartisan support for that, sure, because it's hard to imagine that being a partisan issue unless one party is flagrantly corrupt or something like that. But we don't have a party of corruption. For most things that you might want to do as sort of a pro-democracy constitutional reformer, though, there's going to be a partisan effect. So take the Electoral College, for an example. It turns out that the Electoral College doesn't reliably favor one party over the other. But in a particular historical period, it's going to look like it does. So in recent history, it seemed that the Electoral College has favored the Republican Party. The Democrats have been the ones saying we should get rid of it. Go back to 2000, George W. Bush wins the Electoral College, loses the popular vote. John Kerry, then almost in 2004, won the Electoral College, lost the popular vote. With like 10,000 more votes in Ohio, he could have done it. And if that had happened, both parties would have been stung, losing the Electoral College, but winning the popular vote. Maybe it could have changed. But that moment passed. And now I think no matter who's being favored and who's being disfavored, the party that thinks the Electoral College favors them is going to defend it. You won't get an amendment. And here's the worst part. They won't think that they're doing it because of partisan advantage. So you can look at the debates out there about the Electoral College. People say things that are crazy, right? They make no sense. They don't fit the facts at all in terms of why the Electoral College is a good idea, but they believe them, right? They don't understand that they are engaged in motivated reasoning, that their partisanship leads them to prefer a particular outcome, and they come up with reasons for that. So partisanship is obstructing our ability to reform the Constitution, and the way that human beings think, we don't even understand that's what's going on.
Wow. So we only have a couple of minutes left on this panel. This panel is called Debating the Constitution. So with all of your historical knowledge, constitutional knowledge, what should the audience take away today about the significance of the Constitutional Convention and the debates that occurred there?
Well, it's a constant challenge. Each generation has to face its own difficulties. And there have been real crises in the past. There have been times when the government was not very democratic. There have been times when we had terrible inequality and terrible oppression. And we did manage to get through all of those. Now, like sometimes it took a civil war and a reconstitution of the American political order. And when you have things like that, there are really difficult questions about what you do going forward. But overall, I remain relatively optimistic about the whole American experiment. And I think that is one of the lessons of history. You can look back and you say things were bad in the past, but they did get better. And the lesson that I always try to tell my students to take from this is American history is really a story of people working within the system for as long as they can, as long as they think that it can deliver the results that they need. But if you reach a situation where it can't do that, where the system is irretrievably broken, then the American thing to do, this is not a disloyal thing, the American thing to do is to break that system and make something new.
So right on those lines, it's called, you mentioned debating the Constitution, so that's a central thing to recognize, that at the beginning, there was not agreement, but bitter debate. And there were a lot of people who thought, as I mentioned in my previous answer, the Anti-Federalists, that the Constitution added up to a betrayal of the principles of the American Revolution. And what those who defended the Constitution said was, we're in a time of extraordinary crisis. I mean, the depth of the crisis of the 1780s was really severe and requires dramatic action. We must do something. But you are wrong that in doing something that appears new, that appears in reasonable ways inconsistent with what we thought we declared independence in the name of, that we have betrayed those principles. We've in fact engaged in the crucial work of learning from experience, of applying the lessons of experience that prior political theorists didn't have, and innovating. So rather than throwing out the principles and concentrating authority as some called for, well, Republicanism had a nice run, let's have King Washington and we'll have law and order again. No, let's revise the system in a way that will seem different and unprecedented that few would have accepted a decade ago, but explain why it's consistent in some deep and real way with what this country is about. And that's, in many ways, what the United States Constitution was in 1787, 1788. It was an enormously creative attempt to construct something new that would not have been considered consistent with what came before and show how it was consistent in the face of crisis. So if we find ourselves in a similar crisis, what will be the great act of sort of innovation to explain how something different than perhaps we've tried is in fact a better way of redeeming those principles?
I think just briefly, I am very impressed by the political tradition in the United States, which is that the Constitution houses the two major parties. And what I mean by that is that if you look at the 1790s, which is really when you see partisanship become very feverish very quickly, both sides believed that they were the ones operating within the constitutional framework. And this is a continuing theme throughout much of American history. I mean, even the great heretic, John C. Calhoun, felt obliged to over-argue, but to justify nullification, which is a profoundly anti-constitutional idea. He felt obliged to make an argument that it was, in fact, deeply constitutional and deeply consistent with the Constitution. And I think today we still see conservatives and liberals and Democrats and Republicans, when they're framing their arguments and they're framing their positions and they're framing their place within the broader political order, they're doing so in the context of the Constitution. And I think that's just a testament to the remarkable durability of this document. That everybody, there's really nobody in mainstream politics who says, oh, like we're against the Constitution. And they're really, I mean, outside of the Civil War, and even then, the secessionists believed that the Constitution had been violated by the North. So it's really a remarkable historical phenomenon to see this document be sort of the thread line through all of American politics. It's really extraordinary.
Well, please join me in thanking our wonderful panelists.
Great. Well, good afternoon, everybody. Good afternoon, folks. And thank you so much for staying with us for this last panel of the day. This program, which has been hosted by the Brennan Center and the National Constitution Center, it has offered such thoughtful and insightful conversation from leading scholars, and our hope is that we're going to continue that one with this third panel. You will bear with us. The breadth of this is, the scope of this panel is a little wider. We follow the last two panels to cover everything basically up until today. And so we'll try to get to it all. Without further ado, I do want to quickly introduce my panelists here in this conversation. So to my right is Amanda Shaynor, who is an assistant professor of legal studies and business ethics at the University of Pennsylvania. To her right is Ilya Somin, who is a professor of law at the Antonin Scalia School of Law at George Mason University. And then finally, last but not least, is Alan Trammell, who is a professor, associate professor of law at Washington and Lee University. And so as I said, this panel is going to cover a bit of a longer stretch of time, more or less, where we left off from the convention today, but I'm going to jump into a period that has been mentioned a number of times because it has been so transformative for our country, and that's the Reconstruction period. So we have the Reconstruction Congress, which adopted amendments that the states subsequently ratified to expand the realm of constitutional guarantees. So we have these amendments, the 13th Amendment, the 14th Amendment, the 15th Amendment, critically abolishing slavery, guaranteeing due process, and really non-discrimination by the government in all realms, but specifically voting in the case of the 15th Amendment. Essentially, they sought to make all men equal. And I want to highlight the word men because at that time, we are still in a period where we are talking about men, but equal in terms of their rights and responsibilities under the law. And in doing this, the Reconstruction Amendments also expanded federal government authority, while at the same time constraining state power to prevent these states from debasing the new constitutional provisions. So that long winding up leads to my first question, which is basically, I would love for some of you, all of you, to explain more concretely how the Reconstruction Amendments altered U.S. federalism, this relationship between the federal and state governments and the constitutional order more generally. Grab bag.
Okay, so that's a question we could probably talk all day about. I'll just mention two things. One is obviously the original Constitution included very few constraints on state government's abilities to violate individual rights. There was the Contracts Clause, there was a few other things, but for the most part, states could restrict individual liberty as much as they wanted to, at least insofar as the federal Constitution was concerned. The Reconstruction Amendments obviously add a whole panoply of constraints on state government's ability to restrict liberty and property rights in various ways, both in the 14th and 13th Amendments and 15th themselves, but also in the incorporation of the Bill of Rights against state governments, which was a major transformation. Before that, the general assumption held by most people, including the Supreme Court, was that the Bill of Rights only constrained the federal government. This is often seen as a big expansion of federal power, and there definitely was some expansion of federal power under the Reconstruction Amendments, but it's worth noting that the federal government also gets constrained in some ways. Most obviously, some of the most controversial actions of the federal government before the Civil War were those taken in defense of slavery, like the Fugitive Slave Acts, for example, and some others as well. That was taken off the board. The Citizenship Clause extended birthright citizenship to all people born in the United States, now the subject of litigation once again. That constrained the federal government's power over citizenship, which had been significant before the Civil War. So there are both constraints on the federal government and constraints on the state governments, the ones on the state governments being a big break from the previous relative lack of constraint, but it's worth noting most of that constraint on the state governments is not for the purpose of giving more power to Congress or to the president, but for the purpose of protecting individual rights and liberties for the people within those states.
Well, so I just want to follow up on one thing that Ilya said, which is that, and also, it's such a pleasure to be here. Thank you very much in this beautiful space. So one of the important points here that Ilya highlights is not just a change in the relationship between the state and federal governments, but what happened with the Reconstruction Amendments is really the necessary predicate to the rights culture that we have today in the United States. So before the Reconstruction Amendments, the Bill of Rights only applied against the federal government. So you didn't have a First Amendment right against a state government. You didn't have freedom of religion against your state government unless you had that under your state constitution, but not under the federal constitution. And so what happened after the Reconstruction Amendments, in addition to what was important about them in particular, was that the Supreme Court over a period of time incorporated the Bill of Rights rights, which means applied them through the 14th Amendment against the states. And without that, we wouldn't have those Bill of Rights rights, all of the sort of like panoply of individual rights that we think that we have now, we get actually by way of the 14th Amendment in significant part. And so what happened with the Reconstruction Amendments was not just this important transformation about who the Constitution includes within its polity, right, who is within the we the people, but also this fundamental shift of the relationship between individuals and governments at all levels and in terms of what their individual rights are.
And I'll just add, by putting those together, Ilya talked about the structural elements, what changed structurally as a result of the Reconstruction Amendments. Amanda's talking about the rights culture that gave rise, or that was birthed by the Reconstruction period. And I simply want to zoom out for a moment and note that a lot of this remains very contested history. Some of the historians of the Reconstruction period will say that it's one of the most misunderstood periods in our history. Precisely because of that, there are these ongoing fights about constitutional interpretation, exactly what was promised by these amendments. And it's interesting to go back and to look at the Republicans who were elected in 1864, who were part of that Reconstruction Congress. We often talk about the Republicans and the way that they pushed back against Andrew Johnson, but in fact, the Republicans of that era were not monolithic, the same way that Democrats and Republicans today are not monolithic in terms of the way that they view the Constitution. And so a lot of the debates that we are having today about the nature of federalism, to what extent was federalism transformed by the Reconstruction Amendment? Were these little tweaks? Was this a massive inversion? All of those were live debates. The radical Republicans and the moderate Republicans did not necessarily share a common vision of that. And they debated what the ultimate goals of Reconstruction should be, whether that was going to prioritize bringing Southern states back into the Union, whether it was going to be trying to consolidate the gains of the Civil War, especially with respect to racial equality, and exactly what we mean by equality. It's worth noting, by the way, and we're probably going to get into this a little bit, but there are analogs in Section 1 of the 14th Amendment in the original Constitution. There's a due process clause in the Fifth Amendment that operates against the federal government. So too, there's a privileges or immunities clause. Well, privileges and immunities in the original Constitution, the conjunction doesn't make a difference. It's grammatical. So the question then is, what about that new clause, the Equal Protection Clause? That becomes the font of so much debate that we have to this day. What exactly is that promise of equality? Is it social equality? Is it political equality? What exactly does that entail? And so those ongoing debates very much remain live, and I guess where I want to leave it for the time being is to note that the framers of these Reconstruction Amendments did not think that they were resolving these questions for time immemorial.
So I want to follow up there. You spoke about this contentious debate over the meaning of these new provisions, Alan. today, it seems, at least from my perspective, that the Reconstruction Amendments often get short shrift, at least relative to the original Constitution. Now, there's a lot of litigation over the 14th Amendment, as you said, but it's not always consistent, and it doesn't always seem like that interpretation goes far enough to capture the conditions of today. Now, perhaps that's just my perspective as a constitutional law professor, but I'd love to know what's the cause of this? What's the reason why some, like me, might see that the Reconstruction Amendments are not, they're playing second fiddle to the rest of the Constitution?
I'm not sure that I accept the premise of the question, in that I've heard it said for many years now, precisely what you just said now, that we're giving short shrift to Reconstruction Amendments, but it's sort of like saying if enough people say that something is underrated, then after a while it's not underrated anymore, because most people realize at least something closer to its true importance. So then you can still argue that there are certain aspects of the Reconstruction Amendments that don't get as much attention as they should, but I think if you look at litigation in courts, the 14th Amendment may be the single most litigated amendment. If you look at scholarship in the law schools, once again, probably there's at least as much 14th Amendment scholarship as scholarship of almost any other provision of the Constitution, at least that I can think of. So I think there is a lot of attention. You could say there should be still more, and you could say maybe some of that attention isn't asking the right questions or is reaching the wrong answers, and I think all of that might well be true. But I do think there is a growing understanding both in the courts and in the legal academy, possibly even in popular culture, with the growth of attention to racial issues and obviously the Civil War and its aftermath, that there's a sense that the Reconstruction Amendments, they're at least close in significance to the original Constitution, if not actually on a plane of equality. So I think it would have been legitimate to say 10, 20, 30 years ago, we're not paying enough attention to Reconstruction Amendments, maybe, but that attention has grown, at least since the Civil Rights Movement, and it continues to grow now, I think.
So I completely disagree with Ilya. I think, I wish I could agree with you, but I think there are two levels at which the Reconstruction Amendments have, both historically and sort of in our contemporary moment, have been given short thrift. And one of them is doctrinal. And that's because immediately after the adoption of the Reconstruction Amendments, the Supreme Court, as I teach my students, just punched them in the face, right? Completely from their birth, eviscerated them in really important ways, okay? And probably everyone knows about Plessy v. Ferguson, for example, which interpreted equal protection to permit separate but equal, okay? But in addition to that, we had the slaughterhouse cases, and so under the 14th Amendment, you have three sort of substantive clauses in addition to birthright citizenship. You have privileges and immunities, equal protection, and due process. Most people haven't really heard or thought about privileges and immunities, and why is that? Because in the slaughterhouse cases, very early after the passage of the Reconstruction Amendments, the court just essentially read privileges and immunities, which is where the framers of the Reconstruction Amendments really thought that the big bucket of new important rights and protections were going to be, and essentially read it out of the Constitution such that it's not really important within our constitutional discourse today. But that's where the Reconstruction framers thought you were going to get the most important rights, right? Now we have litigation under due process and equal protection, but we lost that and because of slaughterhouse. And then in addition, in the civil rights cases, the court read the 13th Amendment to be very, very narrow, just about the end of chattel slavery, and potentially a little bit more, including badges and incidents of slavery, but in a very narrow sense. And they decided that the 14th Amendment only applies against state actors, against governments, and not against private actors. Those doctrinal decisions really incredibly narrowed the promise of the Reconstruction Amendments in ways that had very long shadows into the present. And then in addition, in part because of the backlash against Reconstruction, and then later against Brown v. Board of Education, we have a constitutional discourse particularly from originalism, that is focused predominantly on the original Constitution, what the original framers thought, and that is like the core sort of gravamen of what the Constitution means, as opposed to the far more audacious ideas of a radical equality that many of the framers of the Reconstruction Amendments adopted. And which is why I hope that actually Ilya will become right, that those are some of the things that are more central to our discourse, as opposed to sort of like just the original Constitution.
I do want to give Ilya props on one aspect of this, which is that law professors really are thinking and writing about the Reconstruction Amendments a lot more. I also think that Amanda's right, that there's a path dependency. That's the way that I talk about it with my students. There's a path dependency that comes with the civil rights cases, with the slaughterhouse cases, as the big, bold vision that the radical Republicans had for the Reconstruction Amendments winds up getting shrunken down to this almost unrecognizable shadow of itself. And so we see that the Equal Protection Clause, this brand new clause, is suddenly having to do a whole lot of the heavy lifting that the Privileges or Immunities Clause was supposed to do. We see that the Due Process Clause is now doing this backflip of having a substantive element to it, which Justice Thomas calls a contradiction in terms. And in some ways, he's very right about that. But simply pointing to those particular problems, those anomalies, is to ignore the history that Amanda was talking about. The fact that there were certain periods immediately after Reconstruction when we saw an enormous pushback from the Supreme Court, and we're going to talk, I think, about the period of Jim Crow, when you essentially see the Supreme Court giving Southern states carte blanche to largely recreate the badges and incidents of slavery that supposedly had been abolished in the 13th Amendment. One final note is that there was a whole lot of debate in 1866 and 1867 about the extent to which the 13th Amendment already handled a whole lot of these big goals of Reconstruction. Whether the abolition of slavery meant also the eradication of differences in race when it comes to civil rights, social rights, political rights. That, again, was seriously debated. That necessitated, in some ways, the 14th Amendment to try to resolve whether some of the Reconstruction statutes indeed could pass muster. So, again, these debates remain live, and I think that because of this path dependency, that's why law professors essentially are guaranteed full employment, at least the common law professors.
So certainly, recent history is a full employment act for constitutional law professors. I think Amanda's right that it is the case that in the Slaughterhouse case, just 5 years after the 14th Amendment, the Privileged Immunities Clause is largely neutered, and it has not, for the most part, been revived to this day, though some Supreme Court justices, including Clarence Thomas, actually have advocated for reviving it, but so far they don't have 5 votes on the court, nor does the Privileged Immunities Clause have a lot of resonance in popular culture either. That said, I think there has been tremendous attention and also tremendous use for the other 2 big clauses of the 14th Amendment, the equal protection and due process. And I think due process actually is not actually true to say that it was originally meant only to be a procedural protection, because due process of law was actually understood in a different way in the 19th century by most people than the way we today might understand those words. They did not think of it as purely procedural, but certainly with privileged immunities, that work that clause was supposed to do, it never really has done, because by a close 5-4 decision within 5 years after the amendment was ratified, the Supreme Court ruled that the Privileged Immunities Clause has only this narrow significance. I think that was a mistake. I'm not convinced that the civil rights cases was a mistake. That's something we could perhaps have a discussion about. Obviously, Plessy versus Ferguson was wrong, but that was part of a broader historical movement to sort of retrenchment after Reconstruction. But I think the Reconstruction amendments, particularly the 14th, continue to be major focuses of debate and discussion today, and they're a big part of the workload of the Supreme Court and other lower federal courts, and therefore I'm not convinced they're generally underrated, even though there are certainly some things that we should be using them to do that we haven't sufficiently used them for, and there are some parts of them that I think the Supreme Court and other political entities continue to misinterpret.
I would be remiss not to just say that a lot of my scholarship has to do with the Reconstruction. So yes, scholars do love the Reconstruction period, and it does give us job security. And I would also be remiss not to pick up on 2 points. One is Ilya's point, which is that, there is increasing amounts of scholarship and opinions that use the 14th Amendment. That said, where he spoke about the incorporation doctrine, that's also doing a bunch of it, right? So they're not technically writing about the 14th Amendment, but these other parts of the Constitution that the 14th Amendment incorporates so as to apply to the states. And then, just as Alan was bringing up, the debate about the privileges and immunities, and it's what exactly does that consist of? We had some understanding of what those were initially, but what exactly that would mean now, and if that genie could even get back in the bottle, as Justice Thomas tries to argue for so far unsuccessfully. But I do want to raise the point, Amanda, I believe you mentioned originalism, so let's talk originalism. Originalism, for most of you out here, most of you might have some idea, but it's at present pretty much, I'd say, the dominant theory at the Supreme Court in terms of constitutional interpretation. And what it says is basically the meaning of the Constitution was discoverable at the time of the founding, this public meaning of the Constitution, and so the Constitution takes hold at the minute of adoption, at ratification, and that's authoritative. And we can know what it means today and how that applies to current situations today by investigating that. And so if we ask the public then, we can figure out the meaning of questions today. I'd love to know more about the historical evidence for this methodology, this approach to interpretation. Was that something that the framers wanted? Do we have evidence from the convention, the ratification debates, that we are supposed to be interpreting the Constitution in this way that is, reasonably static, back what they thought at the time of ratification?
Can we enlist a guest panelist?
I know. Jonathan, do you want to respond? So we didn't have, so the answer, I think, as Jonathan Knapp's fabulous scholarship will tell you, is that quite the reverse. The framers were not at all originalists, and had I had a little thing to write on, I would have asked for that question because I wanted him to answer it before our panel. But this tells you a few different things, and I'll tell you, so one of the things I study is the way in which social and intellectual movements change the sort of popular meaning and understanding of the Constitution. And actually, where originalism as we think of it today came from is the 1980s. It came from the Reagan Revolution, and specifically from the absolutely brilliant work of Attorney General Edwin Meese, who was Attorney General during the second of Reagan's terms, okay? And in that context, he wrote, and his Department of Justice wrote and rolled out the idea and really popularized, didn't originate, but popularized the idea of originalism as we know it now, and particularly as wed to a certain set of policy and ideological understandings that were popular and that he believed, I think that administration really believed at the time, but that included significantly the backlash to Brown and the idea that affirmative action was unconstitutional. And so the idea of originalism that we have today is certainly not the one, not the mode of the framers. So for example, Jefferson thought that we needed a constitution every 20 years, or for every generation. I guess generations maybe were shorter, okay? Because we had a changing constitutional project, and in fact, that's what we've seen. And one of the things I'll say about Meese, that is one of the reasons I think he's really, even if I substantively disagree with him, was sort of like incredibly thoughtful, is he understood how deeply our Constitution is a living, changing document. So much so that he knew how to maybe seed a set of ideas that would make a whole lot of people think, no, it's not. In fact, it's something that is set, and that is the only thing that the Constitution can be, and we must obey that history, and that leads us to a limited set of understandings of what the Constitution is, when in fact there are many more, and history, including Reconstruction history, might teach us very different lessons about what the Constitution can and should mean.
So once again, I would challenge the question a little bit on two levels. One is actually there is a good deal of evidence of people using what we would today call originalist methodology in the 18th and 19th century. James Madison said at one point, to be sure, years after the Constitution was ratified, that it should be interpreted as understood in the ratifying conventions and by the people. If you look at a lot of 18th and 19th century litigation, you see many examples of judges on different sides of issues making what we would today call originalist arguments. That's true, for instance, of both the majority and the dissents in the Dred Scott case, that you see a lot of arguments about how this was understood in 1788 and 1789. You know, Taney makes one set of arguments, Justice Curtis in dissent makes another, but both of them are making what we would today consider originalist points. The second point that I would make, perhaps more substantial, is that the justification of originalism, I would argue, does not in fact depend on whether the framers were originalists or whether the framers of Reconstruction amendments were originalists or whether any particular person in the past was an originalist or not. Rather, I think the best arguments for originalism are process and consequence based. One set of arguments developed by John McGinnis and Michael Rappaport is the idea that the original meaning is better than living constitutionalism because the original meaning went through a supermajoritarian ratification process and is better for that reason. It's more likely to create beneficial rules when the rules have to go through that process. Another possibility is that there might be other reasons why the original meaning generally creates better consequences than letting judges make changes through living constitutionalism or just deferring to whatever the political branches want. So I think the best justifications for originalism are ones that do not in fact depend on whether James Madison or George Washington or John Adams or other, or for that matter, the framers of the Reconstruction amendments themselves believed in originalism or not. And obviously also there are many originalist arguments and theories of originalism that long predate Ed Meese and the Reagan era. Obviously, there are different versions of originalism, and Ed Meese and his cohorts had a particular version that they were trying to promote, but the basic idea of interpretation in accordance to how the Constitution was understood at the time of ratification, that long predates Ed Meese by probably almost 200 years.
Alan, can I ask you a follow-up question? Perhaps maybe you can talk about a point, clarify maybe the distinctions between drawing on history and originalism as a methodology itself.
That was the deep breath that I was taking.
Yeah,
I was about to say
people
that.
here know we don't really put historians on the court. We put lawyers, and yet we are using these deeply historically inflected arguments to make constitutional moves. And so I'd love to know that distinction.
Sure. This is something that I probably say until I'm blue in the face in my classes, that there is a distinction between history and originalism. History is an effort as best we can to understand what happened in the past, the motivations of the various historical actors. What we do with that is a political normative choice, and it is very much a choice. I would certainly agree that what might pass as at least a pseudo-originalist move can be seen over decades, perhaps even centuries, but the originalist project, in its current form, I think Amanda is right, really is something that traces back to the very recent past. And so how we understand that distinction between history, being attentive to history, being curious about it, drawing on history, is very, very different than saying that that is our destiny. And so it is good and right that judges will consult history, that they will consult historical traditions, experience, but also that they will take account of the consequences of their rulings. that they will look at the actual text and the extent to which there might be tension between text and that originalist gloss, if you will. So, for instance, if you look at a lot of European countries, they very much will consider drafting history when interpreting certain constitutional provisions. But they go beyond that. They use other tools. They're much more eclectic in terms of the tools that they use. Now, that's not to say, well, if they're doing it, they're sophisticated, and therefore we should try to do the same thing. But it is to say that maybe we should be a little bit more reflective about our constitutional methodologies, and to recognize that there is at least a debate there as well. One of the things that drives me crazy is when certain people, and I am casting no aspersions on anyone in this room, but when certain people will act as though somebody who is not an originalist doesn't just disagree with them, isn't just advocating a different methodology, but that those people are not doing law. That is what really drives me crazy, because originalism is not law. It is a methodological choice that we make. And we can make all sorts of methodological choices that are informed by history, but ones that don't require us to slavishly follow that history.
I'm just going to jump in to take a moment to remind the audience to please raise your hand with your question cards. If you have them, people will be around to collect them. And we will get to that moment, that portion of the discussion shortly.
Well, so I'll just follow up a tiny bit about how do we think about not just originalism, but this really broad and very important question about what the role of history and arguments from history should be within constitutional law. Because if you think sort of like more broadly about history, we can learn a ton of things from history. We can learn about good things that we might emulate. We can learn about bad things that we should seek to avoid. We find heroes, we find villains, right? And originalism just looks at a certain part of history and says that's the thing that determines what the Constitution means. Whereas in fact, we can look at a whole broader set of history, including the voices that were locked out from, for example, the moments of the founding or even in Reconstruction, and say that we will listen to more folks, like we'll listen to Frederick Douglass, right? Or Louis Stanton or other people who might actually have been important contributors to the constitutional project. And if we think about history in that much more broad way, history actually can be a source of learning and guidance of what we maybe want to do, but it's also really publicly important, right? So if you think about history, what history does, it's about the stories that we tell about what the Constitution means and what our history means. And that's really important, but it's also important because of the histories and the stories that we leave out. Because what history does is it encodes what is normative, what should happen, what is normal, what should we expect, including from our institutions and from our Constitution. And in that way, I do think it's very important that we try to open up the world of history, including to Reconstruction and beyond, so that we can have more voices in what is the sort of like larger multiracial democratic process.
Can I just piggyback a little bit on that?
Yeah, go
before you jump in, Ilya? to note one example, because we have been talking about the Reconstruction amendments. The history of Reconstruction has been reinterpreted many, many times over the last several decades. And part of that is this project of inclusion. One of the things that many people in this room probably learned is that Reconstruction was an abject failure. Well, that is a particular thesis associated with the Dunning School of Reconstruction, and that's been interrogated quite vociferously by including more voices, including the voices of the freedmen in particular. And understanding that history then sheds light on constitutional praxis, and as I say, what we then do with that becomes a political choice down the road.
Yeah, so it's interesting you made that point about the idea that Reconstruction was an abject failure. It's definitely true that idea originated with the Dunning School and the racists of that era. Ironically, in more recent years, have been taken up by what you might call the opposite side of the political spectrum, the critical race theory people and others who say Reconstruction failed because racism is inherently embedded in American history and institutions, and therefore we need to reject this entire sort of project of of liberalism and instead have something else. So there's a kind of convergence in the Dunning School and some people on the far left and saying the Reconstruction was a failure, when I think in reality what happened is it didn't succeed nearly as much as it should have and could have, but it was still a big improvement compared to what came before, which was, of course, was slavery. In terms of thinking about originalism in history, I agree originalism in sort of historical research is not the same thing, because originalism asks a particular set of questions which is narrower and different from those that historians might ask in other contexts. So you might say, why, ask those questions that originalists say we should ask, as opposed to just look at the entire sweep of American history and include all the possible voices. One possible answer is that the original meaning is what went through the supermajoritarian process of lawmaking, whereas what people thought at other times, while it might be right or wrong, that's not what went through it. But the other is that I think if you look at the two big moments of constitutional transformation in American history, where the text of the Constitution was created and changed, the original Constitution, and then the Reconstruction era with the 13, 14, and 15 amendments, you see periods when the ideals that people were trying to promote were actually really good ones, those of Enlightenment liberalism, liberty, and equality. And if we're going to choose sort of what periods of history we want to build constitutional interpretation on, it should be ones that promoted those high and beneficial ideals, even if though they certainly didn't fully succeed in instantiating them. If you want to be more inclusive and include the long sweep of history, then you're going to include, it's easy to say you want to include the voices of women and minorities, but if you're going to include all periods of history and all evidence from all eras, then you're going to get the redeemers, the people who wanted to reverse Reconstruction. You're going to get all sorts of horrible and unjust political movements from various periods. I would say one reason why I'm willing to be an originalist about the US Constitution is because the lion's share of the original meaning of our most important constitutional provisions was created by these two generally beneficial and liberal-minded movements, the original framers, and then even more so, the Reconstruction framers. If we had a different history, then I think that would be an argument against originalism, at least from my point of view, where I think originalism, like any constitutional theory, has to be justified by its results rather than because people who lived 150 or 200 years ago, we have some sort of inherent obligation to obey their will, which I don't believe that we do.
I'm going to move away from originalism for a second.
Forever?
No comment. During the Articles of Confederation, the debates over them, James Madison itemized 12 defects regarding the Articles, these vices of the political system that existed prior to the Constitution. And so this question is going to pick up on a discussion that Congressman Raskin mentioned in his keynote on a comment or a question made by Professor Edibar. I want to talk about the presidency, right? We had this listing of defects, most of which had to do with state encroachments on each other, not paying these requisitions, not demonstrating that necessary comity for a union. And so notably absent from these defects was anything about the executive. Now, we know the presidency today is not the presidency of the framers. The presidency itself wasn't the primary focus of the convention. Much of the discussion came later after they decided how they were going to vote for the presidency. And we had this sort of backdrop, this ominous sort of vision or specter of King George, right? And at the same time, we had this huge stature of George Washington, who was going to be the president in front of the convention. And so we have this discussion of this office, sort of limited, slighted, and now we have this executive today, which has grown over the period of centuries to become a huge position. I'd love to know how that, I guess I said I was going to move away from originalism, but does today's presidency accord with the originalist theory of constitutional interpretation, how originalists see the Constitution?
I think pretty obviously not. As you said, the power of the presidency has vastly expanded since the 18th century, or even since 100 or 150 years ago. Some of that has to do with the president grabbing power compared to other branches of government, which he's often well positioned to do because it's easier to make decisive action when you're one person in an administrative hierarchy as opposed to when you're 535 people in Congress. But some of it has to do with the growth of the federal government generally, also often in ways not in accordance with the original meaning, which has made it difficult to prevent the growth of executive power in an era when the federal government regulates or taxes or both almost every aspect of our lives. It's hard for Congress not to delegate enormous amounts of authority to the executive, which then further grow this office and further create serious problems and dangers. There obviously is an argument that all of that or most of it is justified because of the needs of the modern world. I largely disagree with that. I think actually having a more complex world means that the case against governing it from one central government actually is stronger in some ways than a supposedly simpler world. But whatever you think about, whether the development is a good one, it certainly is a development that has gone beyond the original meaning. I will make one point, though, about King George, and I'll stop, that we today think of the revolution as a revolt against the tyranny of King George III, and of course, the Declaration of Independence singles out the king and criticizes him. But in reality, British government in the 18th century was already one where Parliament had a lot of power, and the guy who actually implemented and conceived of many of the policies that led to the American Revolution was not King George III, but Lord North, the Prime Minister, who's usually not thought much about today, but he was at least as much responsible as George III, and the framers, of course, well knew that, and that may be one reason why they were at least as much afraid of legislative power as of the power of a separate executive like the king, because they remembered Lord North and his depredations, even if today most of us don't.
I don't have a ton to add. I mean, I think that Ilya's right, that our current imperial presidency in no way accords with the presidency that was envisioned in the late 18th century. The one thing that I would add to that in terms of updating our understanding, I guess I would push back a little bit on the idea that a stronger presidency is not needed in the modern era. I actually do think that a stronger president is needed in certain arenas. You can think about waging war. Our current Congress, all due respect to Congressman Raskin, is not capable of waging a war together. So this might be an area where you would say, okay, it's important that the president have the ability to act with energy and act with dispatch. The flip side of that, though, is that one of the things that political scientists look to most frequently when thinking about democracies in decline is a concentration of executive power. And that is something that we see across a number of countries. It has been a warning sign at various points throughout our history when there has been too much concentration of power in the executive. And it gets especially dangerous when you look at some of the other threats to democracy that are present now, but that's not the question on the table.
I want to add just a little bit to that, is that, so certainly it is the case that we have a far stronger executive than anybody at the founding possibly could have envisioned. Elena Kagan, when she was an academic prior to becoming a justice, wrote a really important article showing how that's been the case for over many different presidencies of all different political stripes. I think that the moment we're in terms of the claims to executive power, though, really stand pretty sharply more aggressive or robust than in earlier eras, except for maybe in the kind of like 9/11 period. But even with regard to that, those claims were for a much more narrow set of things, as opposed to now sort of like more global invocations of Article 2 as giving not just executive power to rule by fiat through executive orders and memoranda, but also to say that that is exclusive and preclusive authority of the executive, meaning that there is no judicial review. So the executive can, for example, ship people off to a foreign country okay, to a really brutal prison without due process, and the argument is, well, that is within my sole authority, and it's a separation of powers problem. It's an overreach of the courts to say that the courts should have any type of review of executive action. And I think that that is quite more aggressive. I'm interested to hear what you all think. Quite more aggressive than we've seen with any modern president.
I think in some ways that's...
I just want to say we have 5 minutes until the Q&A, so use your cards up if you have
it. It is very aggressive, and I condemn it. I've even written about why his attempt to use the Alien Enemies Act in this way is wrong on many, many levels. Google my name and Alien Enemies Act if you're interested in it. That said, FDR and some past presidents at times made similar awful claims during previous crises or even sometimes during invented crises. So the abuses of this administration, while very real and very serious, do have some historical precedents. I think the answer is not to say, well, that means everything is well and good. It's to say it was wrong then and it was wrong now too, but it didn't just purely come out of thin air.
Yeah, undoubtedly we've had this explosive growth in the presidency, which has seen real spikes at certain points. FDR is clearly one of them. Lincoln was one of them. You know, Reagan was one of them. We've seen these periods where the presidency has just expanded in these ways. And then we would also just be remiss not to remember the immunity decision. So Amanda spoke about the preclusive and exclusive presidential powers and what that has meant for politics today. But this is all occurring against the backdrop of immunity. So not only can they not be questioned, but no one can be, or at least one person cannot be prosecuted for, you know, going forward and acting in those ways.
So I think that was a bad decision, and I've criticized it. That said, in the entire history of the United States, not once have we actually criminally prosecuted and successfully convicted a president for things that he did while in office, even though, frankly, there are times where we should have done it. Like FDR, I think, should have gone to prison for the Japanese internment, and there's other examples like that. And the immunity decision itself, it is, to put it mildly, not a model of clarity. It does not simply say the president gets immunity for everything he does while in office. Rather, it says for core inherent powers, he has total immunity. For other official acts, maybe he has immunity and maybe he doesn't. Maybe we'll tell you in a future decision how much immunity he has in those situations. So that, I think, was a bad decision. It's vague, it has problems, but it should not be said that it gives absolute immunity for everything a president does in office, because it doesn't say that. And to suggest that, I'm not that you necessarily suggested it, but to suggest that it does merely just reinforces certain hubris that currently exist in the White House or may exist in the future. Much of the import of that decision actually remains perhaps for future decisions to interpret and decide.
We'll be seeing what my law school students think about that after I grade their exams.
Slight historical correction, Ulysses Grant got a speeding ticket for riding his horse too fast.
Duly noted, I should have remembered about that, and I apologize for that omission. Though, as I understand it, that didn't actually go to court. Like
that's true.
The law enforcement officer gave him the ticket, and to his credit, he did not say, "I'm the president, so I get to do what I want." He said, "Okay, fine, I'll pay it."
Yeah.
Okay. So I have a few audience questions. I'm just going to chime in with one that stands out to me. Is it truly objective, balls and strikes, that is being done at the Supreme Court? Is balls and strikes actually this mode of constitutional interpretation? And if it's not even being done, is it possible?
Just before this panel, Alan and I were talking about how we're both baseball fans. So I do think balls and strikes is a reasonable way to model it. It models the idea that judges are supposed to be neutral and are supposed to not just impose their personal preferences. At the same time, if you are a baseball fan, you know that what's a ball and what's a strike is sometimes ambiguous. You also know, and there's a lot of evidence for this, that different umpires have different strike zones. Some might be a bit higher, a bit lower than others. So while I think this is a useful metaphor and a useful ideal to strive for, when you think about it a little bit more carefully, it also reveals that things are not always clear-cut, and that different umpires, or in this case, different judges operating in good faith, might still come to different conclusions or even use somewhat different methodologies to reach those conclusions. So the balls and strikes metaphor, properly understood, does not mean that there is a unique and easily discoverable set of correct answers, that will just fly off the page of the Constitution or of statutory law. Sometimes that's true, but other times, as with some of these relatively vague phrases like privileges or immunities, necessary and proper, and so on, there's going to be ambiguities, and there's going to be a lot of difficulty in figuring out what the correct resolution is.
So our Constitution is incredibly short and has very open-textured language like equality and liberty. And it's also, as an earlier panel discussed, incredibly hard, at least in modern circumstances, to amend. That puts a lot of sort of hydraulic pressure on courts to do interpretation as incredibly huge changes in society and economy, et cetera, occur. And because of our political moment, we have a lot of things have pressed upon this particular court, and a lot of sort of serendipitous, I guess, I don't know, like contingent facts of life that have meant that we have a court that is really sort of like minority rule within, we have a court that's very not representative of the American public. And part of that just has to do with when justices died, and it also has to do with the whole Merrick Garland situation, okay? And that has meant that we have a very specific court that is doing different things than I think a lot of folks necessarily would choose themselves. One of the things that means, I think, is that we do need court reform, particularly in terms of having term limits for justices, so that every president or every term gets to appoint a justice, which means that we will have a more representative and a less sort of like politically fraught sort of like push towards grabbing seats on the court with the goal of controlling what constitutional meaning is in important ways.
Let me just add two things to this part of the conversation. One is that there can be very, very different methodologies in terms of how a judge approaches a statutory interpretation question, precisely because statutes are passed by a majority of Congress. They can be relatively easily repealed, as opposed to constitutional interpretation. Those are very, very different enterprises. And I think that you can be a textualist when it comes to statutory interpretation, but then recognize that a constitution is a fundamentally different document. It's a framework document. I think that Professor Roosevelt was alluding to at least that particular conception of the Constitution. And to recognize as well that there is not going to be a single right answer to the meaning of these open textured provisions like equal protection, due process, and the like. There will be certain provisions that are seemingly ironclad. For instance, that the president has to be at least 35 years old. Some of us also think that the 22nd Amendment is ironclad, that the president only gets 2 terms, but apparently that's up for debate now as well. And so I would simply note that balls and strikes, Ilya's right, is a useful metaphor. The one other thing that I would say is that when we think about balls and strikes, it implies that there is a methodology. And that doesn't necessarily mean a single methodology that people have to adhere to. We talked about originalism earlier. In fact, throughout most of United States history, there has been a pretty eclectic approach to constitutional interpretation, drawing on all sorts of different sources in trying to understand how we cash out the Constitution today. And again, to come back to something I was saying earlier, I think that it behooves us not to cast aspersions on people who disagree with us methodologically to suggest that somehow they are not doing law if they don't share that methodology.
Yeah, so I want to sort of combine a couple questions here, but it picks up on Amanda's point about amendments. John and I wrote about amendments in our book, The People's Constitution. The Brennan Center has taken a position about Supreme Court reforms. I've had many others. And I guess I want to sort of combine some questions and bring it back to the Articles of Confederation. So the Articles of Confederation are OG, or our OC, as you will, the original Constitution. Turns out that the Articles were just this first draft, and it raises the question, is this just a second draft? You know, when we were writing this book, I wrote a piece for The Atlantic called America Needs a Third Reconstruction. Does America need a third constitution?
I say yes. And in fact, that's one of the projects that I'm working on right now. I alluded earlier to various indicia of democracies in decline. A number of political scientists recently have been writing about this. In addition to concentration of power in the executive, they will point to rising income inequality. They will point to vociferous debates about who is included within a polity. And they will also, fourth and finally, what did I say? Concentration in the executive, rising income inequality. Oh shoot, I'm forgetting the fourth one.
The Department of Education?
Wow, touche. In any event, we have all four right now going on in our country for the very first time. So I know that people will say we have weathered significant storms in the past, we have survived a civil war, but we have never faced quite the same challenges that we do at this moment in time. And I don't know exactly what that looks like. Article 5 probably is not, at least if you subscribe to a notion of popular sovereignty, the only way that we can amend the Constitution. And exactly what that looks like is something that I think scholars and the people need to be grappling with, lest we find ourselves in another civil war.
So I'm in principle open to the idea of a third constitution if it was likely that a modern constitutional convention or similar enterprise would in fact result in a better constitution that exists now. I'm not optimistic that would be the case. So before resorting to that, I would suggest we try to opt for better and stronger enforcement of the Constitution that we already have, because many, not all, but many of our problems actually result from departing from that Constitution. So for example, many of the most cruel and unjust policies of the federal government right now and for many years have been in the field of immigration. Under the original Constitution, as James Madison and Thomas Jefferson pointed out, the federal government doesn't even have the power to restrict immigration. If we go back to that, or at least go back closer to it, we won't have ICE agents grabbing people in the middle of the night and acting like jackbooted thugs. We won't have a lot of the cruelty and evil that we have in our society. Similarly, the war on drugs is not authorized by the original Constitution. Remember, they had to have a constitutional amendment in order to allow alcohol prohibition to be federally prohibited. That's because there's no such power to prohibit possession of substances and for the federal government to determine what is allowed to go into your body and what isn't. If we enforce that limit on federal power, we would eliminate many of the other injustices in our society. About half of all federal prisoners are war on drugs prisoners, and about 20% at the state level, much of the state war on drugs is also dependent on the federal government. And I can go on with many other examples like this, but part of our problem with creeping authoritarianism in the presidency and unjust and deeply flawed policies is because we've allowed the growth of a wide range of powers that are not permitted under the original meaning of the Constitution. We also have a lot of violations of individual rights that are not permitted under the original meaning. To take just one example, our housing crisis, which is a severe social problem, is in large part a result of exclusionary zoning, which under the original meaning of the Takings Clause of the Bill of Rights, I have an article on this, is not actually permitted, or at least not without compensating people. So there's many examples of this. I don't think the Constitution can solve all our problems, but if we enforced it more rigorously, we could at least greatly diminish a great many of them.
So
the fourth one was extreme political polarization.
Extreme political polarization.
Not that
which
see that.
we definitely have now. Yes. Okay. So I actually really agree with both of you, because I think that actually we have a continuing project of changing constitutions. I don't know if we're even on our third or on our many, many multitudes of constitution. And part of the big question of constitutional law is this question of how to connect the moment of the present to a moment in the past of lawmaking, right? And that really is why how we talk about history and how we've had a lot of history today, right, is really important to how we think about the Constitution. So I teach constitutional law, and I have a bunch of people ask me, like, isn't that horrible today? Like, isn't this, like, you know, really sad to teach constitutional law today? And I'll say, no, I don't think it's sad. I think it's really hopeful and promising, and that's because if the American constitutional project is anything, it is a project of change. We really have, in many ways, sort of like had the idea of Jefferson that we will have a constitution every new generation. We will interpret something that is very short and very open-textured in very different ways. And I think that that means if there are things that you don't like about our current moment, it really is for us, we the people, to build and create a new project, including in response to these 4 bad things that Alan points to, but so that we can have, in our present moment, a constitution that does speak for all of us.
Those words, we the people, as said earlier, were not in the Articles of Confederation, were included in the Constitution. Notably, they were also excluded from the Confederates' Constitution. They went back to the idea of states. So I want to leave the people with some wisdom. What would you, at the end of this discussion, which has been great, so thank you, what would you leave the audience with today?
All right, I'll go ahead and start. Since we were talking about the potential of amendment outside the context of Article 5, what would that look like? And I think that it draws in part on this foundational idea of popular sovereignty, figuring out who we the people are and how we act. Now, we normally think about ourselves as, or we think about the polity as acting through elections, through our representatives. But if we're radically reimagining this, what is the role of states? That's something that a couple of the other panels talked about. And I think that it's at least worth grappling with this deeply unsettled question about whether the states retain any sort of that primordial sovereignty that many of the founders argued that they did in the 18th century. There's an argument that perhaps the founding period itself re-envisioned that, or that maybe the Reconstruction period did. And so I invite creative thought about that.
It's hard to point to just one thing as, you know, the one thing that we should remember. Obviously, there's 200 years of constitutional history over which there's been all kinds of debate from the foundings to present. But I will just leave with this one thought, that the American Revolution, later the Constitution, and even more so the Reconstruction amendments, were born out of suspicion of various kinds of government power and oppression. And at times since then, including in the current moment, we've lost sight of that and have allowed power to grow and to become more concentrated, both in the hands of one man, the president, but also in the hands of the federal government more generally. And when it comes to even state governments, we often have been inadequate in our protection of various kinds of individual rights against their depredations as well. So I think the path forward for us is, the best path at least, is to recapture some of those limits on government power that we've allowed to get away from us, and also, of course, to think in the future about both how we can do what was tried to do during Reconstruction, which is to both expand the amount of liberty that is protected, but also to expand the range of people who get that protection. In that era, obviously, the most obvious goal was to expand the range of people to the freed slaves, but at that time, many also recognized it should be expanded in other ways, including to women. In our time, we have a lot of liberties that are threatened in various ways, but we also need to make sure we expand it to more fully to people who are not citizens, undocumented immigrants, and the like, who are today's analog of blacks victimized by the black codes or the fugitive slave clause.
I really think that the sort of like pressing project of the present is wrapped up in polarization, right? Because the idea of the Constitution is that there is a we the people, and I think there is growing mistrust and concern over whether or not there is a we the people, or whether in fact we're sort of like dividing into different camps, and potentially that, we have a government that wants, certain people to win and other people to lose. Right? There's retribution, and there's sort of like winners and losers, and that's an appropriate thing. And I think our Constitution, no matter what our differences are on sort of like some of the things we think about, it's that the idea is that it is for everyone and that we the people, it requires at a basis that we buy in as a polity to the notion that we want to have a future together, because that's what the Constitution is about. And so I do think that what we need to do is think better about how we can talk to each other across difference and about the importance of the continuing constitutional project.
I think that's a great place to leave off here. Thank you very much for a great conversation. Thank you, everybody in the audience.
Thank you.
Well, thank you everyone for such an enriching day of conversation today. My remarks are just a couple of minutes, so you all will get out certainly on time. Part of this event was commemorating the 250th anniversary of the country that occurs in 2026 next year, and I thought it was really important to reflect on that anniversary, not with uncritical patriotism. Rather, I thought it was a shared opportunity to deeply consider the gap between the country we are in this moment and a country that is living up to the idea of a more perfect union and constantly perfecting itself through government action. And also living up to the constitutional ideals that we talked about on panel 1 and on panel 2, and also the ideals that are actually written into the document for liberty, equality, justice, and other wonderful things that many of us who live in our country want for the inhabitants of it. So how we mark this anniversary, I argue, really, really matters, especially in a moment like this. If it's a vehicle to pat ourselves on the back for being exceptional and wonderful and the greatest country in the world, perhaps, that is a missed opportunity. It's also a missed opportunity to reflect on this anniversary by criticizing the Constitution, calling out its hypocrisies, and attacking our system for simply not working in the way that we want it to in this moment. Both approaches give short shrift, I believe, to the people who created the document, the people who lived under it, and the people who care deeply about it, which I imagine are all of you in this room and also on the live stream. And reflecting on the really remarkable really remarkable conversations that we've had throughout the day, one thought I think has sort of lingered for me. Whatever we might say about the founders' intentions and the original understandings that undergird the Constitution, I don't believe the founders and they in fact did not deny themselves the benefit of testing their original ideas in hopes against the intervening experiences that created the country and system of government that we have now. So in tracing the journey from the Articles to the Constitution, it appears to me that the founders learned significant lessons, and our body politic should heed those lessons, and any modality of interpretation should consider those lessons. I want to leave you all with a quote from Alexander Hamilton. I really love the musical, so I couldn't miss this opportunity. But in the opening paragraph of The Federalist, Hamilton posed a really fascinating question that it's so relevant today. What he said was that it seems to have been reserved to the people of this country, by their conduct and example, to decide the most important question, whether societies of men are really capable or not of establishing good government from reflection, choice, and deliberation, or whether they're forever destined to depend for their political constitutions on accident and force. I hope that our institutions and the collective we the people choose the former. And I want to say thank you all for engaging in this really wonderful conversation, and thank you to the Brennan Center, the Stephen M. Poland family, and also the National Constitution Center, and all of the panelists and moderators for joining us and thinking about what our Constitution means on this really lovely day in a perfect venue in Philadelphia where the Constitution started. So thank you all and have a really lovely afternoon.